almost to call for the president's impeachment simply on grounds of policy disagreement or of something approaching that. Either approach, in my judgment, would destroy the utility and propriety of the impeachment procedure. Something in the middle, a mean between these two, is required, and that is a political judgment, but one going not to policy, but to the fundamental character of the Constitution. I believe that's the essential thing to look for during these procedural wrangles, and I think what the viewer may conclude is that this committee has cautiously and soberly and fairly come somewhere close to that middle. The judgment will be made in a fundamentally political and not narrowly legal sense, but it will deal with the grave constitutional question rather than simply a dislike of the president or a disagreement on policy grounds. May I add to that one short additional question? I, too, am awed by the occasion. It is historic in the way Professor Van Alstyne has described, but I would hold back against using the word grave. Grave refers to 6 feet under. Grave refers to mortality and fatality. The impeachment clause wouldn't be in the Constitution if it were grave. It is solemn, perhaps awesome, but it was put in the Constitution to be used when the necessity might arise. Without speaking to what the Congress ought to do, I want to emphasize this as strongly as I can. If it is done fairly, if it is done openly, if it is done soberly, this political system is so strong that it will be done far short of fatality and gravity, but simply solemnly and seriously.
Bill, let me ask you a question, if I may. How would you now assess President Nixon's chances on the House floor?
I would assess them as very poor. I'm not as well informed as Professor Diamond or many in the audience as to exactly how characteristic of the whole body this committee is. And it may be slightly skewed toward the left, to be sure. But as I've sat through 3 days of debate, and note that Cohen, Freilich, Thornton, Flowers, others who are temperate, who did not seem to come predisposed, who seemed to anguish authentically and not just posturing. And then as they were pressed by Sandman and others on the other side to review the evidence point by point, it seems to me very implausible, really, that the case can be shaped the other way adequately on the floor now to defeat this resolution of impeachment. Indeed, I would forecast that it would carry.
Gentlemen, thank you very much. Without further ado, let's go now to our videotape replay of those 4 hours that led to that crucial vote. Tonight's debate covers just over 4 hours and deals entirely with attempts to modify the language charging the president's involvement in the cover-up of the Watergate break-in.
In the first hour, Charles Sandman urges that attempts to further reduce the charges be dropped. He said simply, let's get on with it. Also in this hour, Tom Railsback successfully argues the president be accused of taking part not in a policy to obstruct the investigation, but rather that it was a plan.
In the second hour, William Cohen outlines the times that he says the president had information, but that information was not passed on to the investigators. But Republican Charles Wiggins maintains that one reason he could not pass on information was that he was not informed. He said that on September 15th, John Dean was up to his elbows in getting money for Watergate defendants, but he never mentioned that to the president.
In hour 3, Caldwell Butler cites passages from the presidential transcripts, which he claims shows the president approved of Gordon Straughn's perjury. Also in this hour, Trent Lott maintains there is no hard evidence the president ever interfered with the FBI.
In hour 4, Wayne Owen says it is the presidential tapes that made a real hard case against Mr. Nixon. Also in that hour, Jerome Waldy charges that it was the president's public statements that cemented the cover-up together until after the election.
Following those arguments, the committee polled its members on the first article of impeachment. Now let's pick things up from the beginning as Congressman Peter Rodino gavels the committee into session.
The committee will come to order. The chair wishes to announce that pursuant to the policy adopted when we considered the rule of procedure for this debate, that it contemplated that there be general debate for a period not to exceed 10 hours and that it was understood as agreed policy that the balance of the time for the consideration of amendments to the articles would not consume more than 20 hours. The Chair wishes to point out that having commenced with the consideration of the articles yesterday for purposes of amendment, 12 hours have already been consumed of that time. However, as the committee certainly understands that the committee can extend time for consideration of the articles for purposes of amendment until we have resolved the entire question. But the Chair would like to state that in the light of some of the motions to strike which are presently before the Chair, the Chair intends to recognize, after a motion to strike has been proffered as an amendment to Article 1 and to each paragraph thereafter, that after an hour's debate has expired, the Chair is going to entertain a motion to move the question, and that the question will then be in order.
Will the Chairman yield?
I recognize the gentleman from Michigan.
I thank the Chairman for yielding. I would not want there to be any misunderstanding about the time limited for debate. My recollection is, Mr. Chairman, that in an earlier version of the rule which was adopted, there was a 20-hour limitation for amendment, but that in the final version the wording was worked around the concept of the 5-minute rule, and the provision does not limit debate to a total of 20 hours, and that while there was an expression of hope that it could be accomplished in that length of time, still, if 12 hours have already been consumed and we haven't yet disposed of Article 1, it becomes very obvious, Mr. Chairman, that it will be necessary to consume more than 20 hours to handle these articles. And in order to extend beyond 20 hours, Mr. Chairman, I do not think it would take any formal action of the committee to extend the time for debate beyond that 20 hours. With regards to limiting debate on a motion to strike to 1 hour, Mr. Chairman, I would indicate that I certainly would interpose no objection to that.
A right to object, and I shall not object. I would like to say, and I hope that others will agree who took the position I did yesterday, that the argument was exhausted as far as I'm concerned yesterday on the articles of impeachment along the line that I suggested. A vote has been taken. There are amendments on the desk that have my name on them, and I'd like to withdraw those because they are aimed at the same point of law that we discussed at great length yesterday. It is my hope, Mr. Chairman, that we will be able to proceed with Article 1 with a degree of discipline that existed yesterday and last night, and no doubt continuing today. There is no way that the outcome of this vote is going to be changed by debate, and I therefore hope that we can, with dispatch, cover the Sarbanes substitute, and there will be no objections from me, no amendments from me, nor will there be any motions to strike from me.
Mr. Chairman? Mr. Chairman.
Flowers.
If I might be recognized for a short minute, knowing of my friend from New Jersey's conservative bent, which I share, I would ask if he would be opposed to my borrowing the paper that he's already got at the desk and at all of our desks and adopt, for my purposes, the same motion to strike that he has proffered to subsection 1, I would be prepared at the appropriate time to offer to subparagraph 2. I think it is important. It's important to me to know here in these debates that we're having this week in this committee on the allegations that are contained in Article 1, and if there are any other articles to them, the specifics of the charge. I think it's important. The gentleman from Wisconsin, I think, agrees with me on this. We discussed it here in the committee last evening, and I believe the other members do. So I propose, Mr. Chairman, I take this time merely to point out that it would be my purpose to offer a motion to strike the paragraph, to seek out the information that would support the paragraph from the members or from the council.
Mr. Railsback.
Mr. Chairman, I have an amendment that I'd like the clerk to read.
If the gentleman will defer, the chair was not recognizing the gentleman for purposes of offering an amendment, since I believe that at this time the chair is going to state that it's going to be its policy to first recognize those who have perfecting amendments, and I had already indicated to Mr. Hogan that I would recognize Mr. Hogan for that purpose.
Am I recognized for the other purpose then?
The gentleman will be recognized. And I would like to also state that if the gentleman from Alabama was asking that his name be substituted for that of Mr. Sandman, which appears on the motions to strike that are on the clerk's desk, there's no objection. I'll entertain that. So that the gentleman will have that proper motion before the clerk's desk. It is not there.
Mr. Chairman, I think I still have the time, do I not?
The time is reserved to the gentleman for offering his motion after the gentleman from...
No, I wasn't gonna, that isn't what I wanted to speak on. I wanted to congratulate my friend from New Jersey for what I thought, he says it's about time, for doing something that I think is very wise and very prudent and very thoughtful on his part, and also in the best interests of this committee. And once again, I think he has shown his good sense. As far as my good friend Mr. Flowers, I hope that if he does move to strike every single numbered item, that we maybe can expedite the debate on each item, because frankly, I think a lot of us thought that there was a great deal of repetition last night. I think we ought to be able to either present the case for or against in a little bit more expeditious manner. I'll yield back, Mr. Chairman.
Mr. Rangel?
I want to join in the praise given to the distinguished gentleman from New Jersey for withdrawing his motions to strike in the interests of saving time, and then ask the distinguished gentleman from Alabama that if indeed it is his purpose to bring facts before this committee as it relates to specifics of presidential wrongdoing, and certainly not to strike it, but to serve as an educational function, and recognizing that a motion to strike may serve as that parliamentary vehicle, I was wondering whether the distinguished gentleman from Alabama would accept either staff or members reciting specific dates and times that support that particular article. I think if the question really is one to educate the general public, then perhaps we could recite that information. But certainly, whether any of the members of this committee agree on the standard of evidence that we will be using, there is no question that we do know what evidence we're using at this time. We may differ on the quality and the quantity that we think is necessary to support an article of impeachment, but I asked the distinguished gentleman from Alabama that if indeed he wants to educate the general public and have specifics, would not he consent to those specifics being given either by staff or members, to support the article so that we can move on and finally get an opportunity to vote on this historic question.
Is this directed to me, Mr. Engel?
Yes, I yield.
Well, I think that the only way in which we can elicit this information is through this vehicle, as it pertains to each one of the sub-paragraphs, which tend to buffer or support the general statement in paragraph 2. And that my purpose is to elicit the information and to find out what evidence there is. And I would hope that the staff and members of the committee would be able to respond expeditiously, as my friend from Illinois says, and we will not take a great amount of time, but I do not think that we should sacrifice thoroughness for expedition here.
The question is, Mr. Flowers, is that if we were to read paragraph 2, and if in fact staff or a member of this committee would give you information and specifics as to what the President did or did not do to support that paragraph, would you accept that and be prepared to allow the committee to vote as to whether or not this is sufficient evidence to support that paragraph?
I would say to the gentleman from New York that the only way a member can gain the floor is to offer an amendment at this point. And there is no other parliamentary device for a member to gain the floor having already used up the 5 minutes which we were allocated in general debate on this article. And for that purpose, I don't see that the parliamentary situation would allow that.
If you stick to the word debate, there's no question that we have to deal with the motion to strike. But I'm certain that the chair would allow us, as Mr. Sarbanes goes down the paragraphs, to give that specific information which we have used to support it. And then, if that was done, there would be no need for 38 members to debate it. It'd be a question as to whether we agreed with it, and we could vote on it. I yield back the balance.
Mr. Chairman, parliamentary inquiry.
Gentleman will state it.
Mr. Chairman, I'm interested, as you know, in Article 2, a proposed Article 2 and a proposed Article 3, and I just want to be sure that I understand what our procedure will be for today. I understand that you will entertain perfecting amendments, which will be discussed, and that then you propose that with respect to motions to strike articles for purposes of debate and for getting additional information, such as the gentleman from Alabama suggests, that you will entertain a motion to close debate, a motion on the previous question at the end of 1 hour's time with regard to each one of the paragraphs. Is that correct?
Or if a member would move the previous question
or an earlier time, but not to exceed 1 hour of discussion with regard to information with respect to each of the sub-paragraphs.
That is correct.
Thank you, Mr. Chairman.
Mr. Chairman, I have a parliamentary inquiry.
Thank you, Mr. Chairman. Let me say I concur in Mr. Sandman's statement. However, we're certainly not bowing just because we want to be bowing. We're bowing to the obvious, and the obvious is that we don't have the votes. We are not deserting our position. We think it was a proper position. On yesterday, those who believed as deeply as we did were not resorting to dilatory tactics, has been reported in some places. But we definitely felt that the President of the United States should be able to answer the charges that were being made against him, and they were not specific. They're still general. And that's the way they're going to remain. But I would like to, at this juncture, Mr. Chairman, point out that there has been some misinformation going on across the country that had we been successful and made these articles specific, that they could not have been amended on the floor of the House. I know the chair knows, and every member of this committee knows, that we're not going to grant in the Rules Committee a closed rule on this matter. It'll be an open rule and subject to amendment on the floor. So if there are any additional charges that wish to be brought, or times or places under any of the articles that have been mentioned here that wish to be included, it could have been included by amendment on the floor of the House. And I'd just like to make the record straight that here's one member, and I'm sure that there's going to be 14 other members on the Rules Committee, when this matter comes up there, are going to be voting for an open rule.
The chair would like to point out that while no rule has yet been established, since that will be a matter before the Rules Committee, the chair certainly is going to recommend that there be full and free debate so that this matter, which is of such moment, be considered as it should be considered deliberately and fully by the full House. And therefore, I think that the members' recitation of what could be expected is indeed in order. And now we'll recognize for parliamentary inquiry Mr. Daniels.
Mr. Chairman, at the appropriate time, I will wish to offer a perfecting amendment to paragraph 4 of Article 1. I wish to reserve the right to offer that amendment, and I do inquire as to when would be the appropriate time.
Perfecting amendments are in order at any time. The bill is now being read by way of the vehicle of the substitute, and it is amendable at any stage.
Should the amendment be offered at the time we take up subparagraph 4 for consideration?
No, the amendment may be offered at any time.
If it's
but I am going to now, for the purposes of recognizing Mr. Hogan, who has already proposed perfecting amendments, I will recognize him for 5 minutes and ask him. The clerk, however, has not read his amendments, I think.
Thank you, Mr. Chairman. I have 2 amendments at the desk, Mr. Chairman, and I would ask unanimous consent that I be permitted to address myself to both of them at the same time and that we vote on them at the same time.
Without objection, it is so ordered.
Amendment by Mr. Hogan. On page 1 of Article 1, on the second paragraph, and on page 2, paragraph 5, strike illegal entry where it occurs, and insert in lieu thereof unlawful entry. Amendment by Mr. Hogan. On page 1, paragraph 3, quoting subparagraph 1, after the word making, insert the following new language: or causing to be made.
Maryland.
Mr. Chairman, we should be aware that my amendments are to the Sarbanes substitute, which is before us.
An amendment.
Mr. Chairman, I believe they're being distributed.
Well,
am I recognized, Mr. Chairman?
Be nice to see him. The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. When I returned last night, my wife, who had been watching the deliberations on television, reminded me that many of the prior impeachments were not handled by the Judiciary Committee, and she wondered if the deliberations would take as long if Speaker Albert had entertained sending it to a select committee made up of non-lawyers, if it would take us as long to complete it. She also then said that she understands full well why lawyers are barred from serving on grand juries. Now, having said that, I have before the committee 2 what I guess could fairly be characterized as legalistic amendments. However, I do think they're important. Addressing myself to the first one, Mr. Chairman, where we use the word illegal entry rather than unlawful, I note that in the D.C. Code, Section 20, Title 22, Section 1801, burglary is entering with intent to break and carry away any part thereof. And while the Watergate burglary is very frequently referred to as a burglary, it is not, strictly speaking, according to the D.C. Code, a burglary. It's a breaking and entering. So what my amendment does, it tries to track the language of the statute in Title 22, Section 3102, relating to unlawful entry on property. It also, I understand, tracks the language in some of the indictments on conspiracy. So I do think that while it may seem to be a minuscule change, I think it strengthens our situation by having it more accurate. The second one, Mr. Chairman, would, in paragraph 1, after the word making, include or causing to be made. I think the record substantially supports the addition of this language. While the President personally did in fact make false and misleading statements, he also induced others to make false and misleading statements. So I would urge that both of these amendments, which I consider perfecting amendments, be adopted. I yield back the balance of my time. I yield to the gentleman from Maryland.
Mr. Chairman, I would like to say that I think, as my colleague from Maryland has stated, that these are helpful and valuable perfecting amendments. I appreciate the legal scholarship, really, that has gone into these amendments. I think they do help to improve the proposition that is before us, and I would hope that all the members of the committee would recognize that and accept these amendments to the substitute.
Mr. Chairman, I move the previous question on my amendments.
The question is on the amendment offered by the gentleman from Maryland, and I understand these are being offered en banc. All those in favor of the amendment, please say aye.
Aye.
All those opposed? And the amendment is agreed to. I recognize the gentleman from California, Mr. Danielson.
Mr. Chairman, I have an amendment at the desk.
The amendment.
Amendment to Article 1, offered by Mr. Danielson. On page 2, subsection 4, strike the word "and" in line 3, and strike the semicolon after the words "Special Prosecution Force" in line 4, and add at the end of line 4 the following: "and congressional committees."
Mr. Chairman, the thrust of subparagraph 4, as is apparent, relates to the interference by the President, or endeavoring to interfere, with the conduct of investigations by the Department of Justice, the FBI, the Office of the Watergate Special Prosecution Force. I should like to add to those agencies congressional committees. I have in mind specifically the House Committee on Banking and Currency under the chairmanship of the Honorable Wright Patman. You will recall that a couple of days ago, during the early stages of our debate, I quoted at some length from the September 15, 1972 tape transcript of the conversation in the President's Oval Office, in which it was apparent that the President, his Chief of Staff, Mr. Haldeman, and Mr. Dean were planning on how they could possibly prevent the House Committee on Banking and Currency from conducting investigations into the whereabouts, the source, the transmission of certain funds that were found in the possession of the people arrested in the Watergate on June 17th. The plan was rather elaborate. The President first offered to do so himself, and then he suggested that Mr. Ehrlichman or Mr. Mitchell or some other person contact and enlist the aid of Gerald Ford, who at that time was a minority floor leader, various other members of the House of Representatives, to prevail upon Mr. Patman to desist from conducting his investigation. In all fairness, I want to point out that Mr. Dean's testimony later was that the members of the House who were being prevailed upon to, in turn, prevail upon Mr. Patman were not aware of the fact that they were being used for this purpose. The guise of the argument was that what with the trial forthcoming of the burglars, maybe I should say the unlawful entrance, that a congressional hearing into their activities might prejudice their case and might interfere with their civil rights. This was explored at some length, and I do not wish to reiterate it here because you all have heard it. In addition, they had a plan whereby they were to contact Mr. Rothblatt, who was the attorney for 4 or 5 of the defendants, and Mr. Bittman, who was the attorney for Mr. Hunt, and have them in turn call upon Mr. Patman and urge that he not conduct the investigation because it might interfere with their client's civil rights. Other testimony before this committee is that Mr. Bittman acknowledges that he was so contacted and was requested to get in touch with Mr. Patman, but that he declined to do so. The records of the House Committee on Banking and Currency reflect that there was a letter from Mr. Rothblatt making the same argument. Carrying on, I have also in mind the Senate Select Committee on Campaign Practices. I might add, going back, that the Banking and Currency Committee was not able, due to these efforts, to muster enough votes to pass a resolution to conduct the investigation, and the investigation was postponed. The fear in the minds of the President, Mr. Haldeman, and Mr. Dean, while they talked in the Oval Office, was that if Wright Patman was able to issue subpoenas and call in the witnesses, he might uncover almost anything. It was a can of worms, and he didn't know what might happen if Patman were given a chance to conduct the investigation he wanted. Their fear was the disclosure of the fact that the $3,200 in new consecutively numbered bills found at the Watergate did in fact come through a Florida bank account, could be traced back to a Minnesota donor, and had been laundered in some kind of an operation down in Mexico. Proceeding on to the Senate Select Committee, we do have testimony from some of the tapes furnished to us by the White House that at various times in the proceedings, the President counseled his aides to, if they did appear, to stonewall it, to say nothing, to say they could not recall, to take the Fifth Amendment, to do anything but not let the plan come out. This, I submit, is a specific example of an effort to obstruct and interfere with the lawful function of that committee. And thirdly, I refer to our own committee, the House Committee on the Judiciary. In connection with the cover-up plan, which I submit is still going on, the President has openly and notoriously and knowingly persisted in defying this committee and its lawful subpoenas, and has failed and refused to turn over the documents we have requested. I respectfully submit that we should include within subparagraph 4 congressional committees.
Mr. Wiggins.
Mr. Chairman, I do not oppose the motion of the gentleman from California to include the language. The problem is, will the prosecutors in this case be able to prove the charge? Let me review my recollection of the evidence with respect to whether the President interfered with a congressional committee, first in the context of the Patman hearing. Bear in mind, ladies and gentlemen, that there was no Patman hearing. What we had is an intention on the part of the chairman, Mr. Wright Patman, to do something, which he announced publicly. But the members of his committee, including 6 Democrats, would not go along with him. He was thwarted not by the President, but by the members of Congress who were on his committee, and that hearing, that congressional activity, never got off the ground. I'm not willing to attribute to the 20 members who voted against the chairman of the Banking and Currency Committee any corrupt motives, and don't regard them as co-conspirators in this case. Moving next to the Senate Select Committee. The only interference of the President with the conduct of the Senate Select Committee was for a period of time a consideration of the invocation of executive privilege with respect to his aides testifying before that committee. As we all know, shortly thereafter, that policy, which was characterized as stonewalling it, that is, the invocation of executive privilege, that policy was abandoned by the President, and the policy thereafter was that all of his aides would go before the Senate Select Committee and testify freely without claiming privilege, and of course we know that is in fact what occurred. The legal question on the basis of those facts is whether or not we are going to punish the President in the context of impeachment for considering the invocation of executive privilege. Now, if so, future presidents are in jeopardy because the executive privilege concept is still alive and well in American jurisprudence. Finally, with respect to interference with this committee, I think probably we will debate that more extensively in the context of a separate article, and so I will not address myself to it now. But in essence, I say to my friend, we're still talking about punishing the claim by the President of a right to withhold evidence by reason of his assertion of either executive privilege or a claim of non-relevancy. And I don't understand that our system of government prohibits the punishment of a good faith claim on a narrow and rather confused legal issue. And so in conclusion, I'll say to my friend, I don't oppose your amendment at all. I just simply indicate that the facts do not support.
Mr. Chairman, I respond very briefly.
You can if I yield to you, and I'll be pleased to do so.
I thank the gentleman. I'm sorry, I thought he had concluded. I don't disagree with my colleague's argument. I want to make eminently clear, and I thought I had, that the vote of the members not to hold the committee meeting was certainly not corrupt. They were the background to which I've alluded was not brought to their attention, and I make no assertion and no implication that there was any corrupt voting. On the other portion, I agree that whether or not this article can be proved is a matter of proof, and that would have to be resolved, of course, at the appropriate time in the trial in the Senate. But we're bringing here under impeachment, all we're doing is bringing an accusation. I think there is sufficient evidence to warrant that the matter be tried, and therefore I urge the adoption of my amendment.
The gentleman from Illinois is recognized for 5 minutes.
I intend to support this amendment. While I do not favor the entire article, it seems to me that nevertheless, in perfecting this article, we should include the words and congressional committees, as suggested by the gentleman from California, Mr. Danielson, because in my opinion, the defiance of this committee by the President in refusing to provide information to this committee is a serious situation, and one which, in my opinion, suggests valid grounds for an article of impeachment. I propose at a later time to offer a separate article on this ground. And I'd like to call attention to the fact that following the President's refusal to respond favorably to our subpoenas, we notified the President on May 30th that this would be regarded as an impeachable offense if he did not comply with our subpoena. Now, I don't agree with the interpretation of executive privilege as suggested by the gentleman from California, Mr. Wiggins. I think that the doctrine of executive privilege must yield when the office of the President is being investigated. Otherwise, the President is in the position where he can dictate what he wants to provide this committee with and what he does not want to provide the committee with. It seems to me that in order for us to carry out a valid and full and fair investigation, we need all of the information which we have required and which we deem necessary. And our position has been definitely strengthened by the recent opinion of the Supreme Court, which has knocked down this doctrine, this so-called doctrine of absolute executive privilege. And in offering a motion yesterday that we defer our proceedings for the purpose of giving the President an opportunity to provide the additional tapes that we've requested, it seemed to me that an opportunity again was offered for him to provide the kind of cooperation which it seems to me he should have been providing throughout these proceedings. And so I think it is perfectly valid for us to put in this article the inclusion of the words congressional committee, because in addition to his interference and misuse perhaps of other agencies of government, his defiance of this committee is, in my opinion, a most serious matter and is entitled to be presented to the House of Representatives together with this proposed article, as well as a later article which I propose to introduce. Thank you, Mr. Chairman.
I recognize the gentleman from Illinois, Mr. Railsback.
Mr. Chairman, I'm opposed to the article by the gentleman, Mr. Danielson from California. Anybody that had any knowledge, I believe, of the possible motivations at that particular time of the Patman Committee, I think that who was on the receiving end of a possible investigation to be conducted by Wright Patman probably would have had good reason to try to avoid what they believe very easily could have been a political fishing expedition. And I think it is very significant that the members of his own committee decided not to go along with the chairman in conducting that kind of an investigation, which I think many of them believed was going to be a political fishing expedition. In respect to executive privilege, I agree with the comments made by the gentleman from California, Mr. Wiggins. And as far as refusing to comply with our subpoenas, it's my own belief that that failure should not constitute an independent or separate either article or item in an article of impeachment. I think the president probably had a right to assert executive privilege, even though I'm convinced that if it had been taken to court, the court would have ruled against the president. I think, Mr. Chairman, what we're doing here is we're adding something that cannot be proved and that would certainly weaken the Article 1.
Will the gentleman yield?
Yes, I will. Be glad to yield.
I thank the gentleman for yielding, and I'd just like to associate myself with his remarks. I think that in considering the language in an article of impeachment, we must always bear in mind that it must rise to the gravity of a crime against the constitutional system. And I agree with you that this proposed additional language simply doesn't meet that test.
The question is on the amendment offered by the gentleman from California. All those in favor of the amendment, please signify by saying aye. Aye. All those opposed? No. The chair... A record vote is demanded, and the clerk will call the roll. All those in favor of the amendment, please signify by saying aye. All those opposed, no, and the clerk will call the roll.
Mr. Donahue. Aye. Mr. Brooks.
Aye.
Mr. Kastenmeier.
Aye.
Mr. Edwards. Aye. Mr. Hungate.
Aye.
Mr. Conyers.
Aye.
Mr. Eilberg.
Aye.
Mr. Walde.
Aye.
Mr. Flowers.
No.
Mr. Mann.
Aye.
Mr. Sarbanes.
Aye.
Mr. Seiberling.
Aye.
Mr. Danielson.
Aye.
Mr. Drinan.
Aye.
Mr. Rangel.
Aye.
Miss Jordan.
Aye.
Mr. Thornton.
Aye.
Ms. Holtzman. Mr. Owens.
Aye.
Mr. Mezvinsky. Mr. Hutchinson.
No.
Mr. McClory.
Aye.
Mr. Smith.
Aye.
Mr. Sandman.
No.
Mr. Railsback.
No.
Mr. Wiggins.
Aye.
Mr. Dennis.
Aye.
Mr. Fish.
No.
Mr. Maine.
No.
Mr. Maine.
No.
Mr. Hogan.
No.
Mr. Butler.
No.
Mr. Cohen.
No.
Mr. Lott.
No.
Mr. Fraley.
No.
Mr. Moorhead.
No.
Mr. Mariziti.
No.
Mr. Latta.
No.
Mr. Rodino.
Aye. Mr. Mezvinsky.
To register my vote as aye.
Mr. Swinsky is
Aye.
voting aye.
Registered as aye.
Mr. Chairman,
Clerk will report.
24 members have voted aye, 14 have voted no.
And the amendment is agreed to. I recognize the gentleman from Illinois, Mr. Railsback.
Mr. Chairman, I have an amendment at the desk, which I would like read.
The clerk will read the amendment.
Amendment by Mr. Railsback. On page 1, beginning at line 11, after the word intelligence, strike all that follows through line 17 and insert in lieu thereof the following new language. Subsequent thereto, Richard M. Nixon, using the powers of his high office, engaged personally and through his subordinates and agents in a course of conduct or plan designed to delay, impede, and obstruct the investigation of such unlawful entry, to cover up, conceal, and protect those responsible, and to conceal the existence and scope of other unlawful covert activities.
Mr. Chairman,
The gentleman is recognized for 5 minutes.
this language replaces the following language. Subsequent thereto, Richard M. Nixon, using the powers of his high office, made it his policy, and in furtherance of such policy, did act directly and personally and through his close subordinates and agents to delay, impede, and obstruct the investigation of such illegal entry, to cover up, conceal, and protect those responsible, and to conceal the existence and scope of other unlawful covert activities. Mr. Chairman and members of the committee, I have a great deal of difficulty believing that Richard M. Nixon, at a particular point in time, contrived any kind of a policy, or at least any kind of a policy that would continue to follow through. And I think the word policy gives the impression of an affirmative, orchestrated, declarative decision that occurred at a given point in time. I thought that some of Mr. Wiggins' objections yesterday were very well made. I think what the record reflects, however, is a course of conduct, or in the alternative, a plan of action over many months, which was responsive to and developed as a consequence of events that occurred. And that's the reason for my amendment. It seems to me that we are going to be asked to prove the charges that we make, and it seems to me that we would have a great deal of difficulty proving that the President had any kind of a policy that we could pinpoint as of June 23rd or July 6th or August 29th, but rather that many of the things that he did were in response to certain events that occurred. That's the reason for the amendment. I'd be glad to yield.
Gentleman from Arkansas is yielding to the gentleman from Arkansas.
I think the language suggested by the gentleman is superior to the language which we have had before us, and I'm in full support of this amendment.
I thank the gentleman.
The gentleman from Texas, Mr. Brooks, is recognized.
Mr. Chairman, I'm speaking in favor of the amendment. I think that basically it reflects the attitude of this committee doing a fair and reasonable job of drawing this language. It's not a pleasant chore to impeach a president. Certainly we want to do it in the most legal and reasonable manner. I think that this language is perfectly adequate to explain the factual situation at that time, I think that it eliminates some difficulties in the minds of some Republicans about policy. I think that course of conduct or planned is quite adequate to indicate the fact situation, and I would commend Mr. Seiberling for his genius in originally working on some of this language, and Mr. Railsback in implementing it and putting it together, and I would hope that we could adopt it without a tremendous delay. I'd be pleased to yield to my friend from South Carolina, Mr. Mann.
I guess he has the time.
Join in expressing appreciation to Mr. Railsback for developing this more definitive language. As we all know, we want to give as much specificity as possible to the general allegations of this article. I think this contributes to that end. It removes a fuzzy area that caused us some difficulty yesterday, and I appreciate the gentleman's efforts.
I spent 5 minutes last evening arguing that the President had, in fact, made it his policy, and I really believe the evidence sustains it. But I will support the amendment because I believe it will make the proof in the Senate much easier and and commend the gentleman from Illinois. That's where the problem will likely be. I thank the gentleman for yielding.
Mr. Chairman, any lawyer worth his salt ought to recognize an improvement when it comes along. I know the concern that Mr. Railsback has had with this language, and I know how he has worked on this problem. I think that the language that he has proposed here this afternoon is a very constructive suggestion. I commend him for the skill that he's shown in developing this language. I would hope that the committee would adopt the proposed amendment.
Since the gentleman mentioned my name, I want to say quite quickly that I appreciate his somewhat over-lavish praise for some very small part I had in this language, and I think the credit is due to Mr. Railsback for finalizing this. And I just want to say that any time we can make an improvement in language to focus on substance rather than on semantics, I think it's a real step in the right direction.
Time
Mr.
of
Chairman.
the gentleman has expired.
Mr. Chairman.
Dennis?
Mr. Chairman, I'd like to address a question to the author.
Gentleman is recognized.
To my distinguished colleague from Illinois, what is your view of the difference between plan as you propose and policy as contained in Mr. Sarbanes' substitute?
Well, if the gentleman will yield.
I'll yield.
Let me say that I have some difficulty myself with the word plan, and at one time it was suggested that the language read course of conduct and plan. And I'm not sure that I can answer that there is that much difference between the word plan and policy, except there seems to be a feeling on the part of the council that I dealt with in drafting that policy seems to give an impression of more of an impression of an affirmative, orchestrated, and declarative decision. I'll tell you, the reason why I took out the word "and" is because I personally favored the word course of conduct, which I think more aptly fits the situation.
Well, if the gentleman will yield further, does the gentleman think that his change gets us further away from the conspiracy theory or nearer to it?
Well, I'm not going to, I really would prefer not to express my legal opinion on that. I think that...
I'd be real interested in your legal opinion on that.
Well, I'll say to the gentleman, what the amendment does is express my belief that there were certain events which occurred which, for one reason or another, the President did not either see fit to respond to, or in some events responded to in what I believe to be an improper way. I don't think that they were necessarily orchestrated. If there ever was a time when if there ever was a time when the President perhaps came close to a policy, it would have been that time, in my opinion, after March 21st, when all of the...
Let me ask the gentleman one more question on my time, if I may.
I'm sorry.
I thank you for your answer. I suggested when I was talking to Mr. Sarbanes yesterday that under his version you would have to first establish the policy before you could use against the President the actions of subordinates. Do you think that that would be equally true or not under your version?
Let me make myself very clear on that. I don't buy imputing criminal responsibility to the President for acts of his subordinates. And I want to make that very clear. I don't believe in inferring anything either. I think that's why some of us on this side believe very strongly that there should be a bill of particulars, or if Mr. Flowers
well, is it your idea that you are taking, by your amendments, you are taking out the possibility of attributing to the President the acts of third persons, which Mr. Sarbanes was definitely, under his theory, attempting to do?
Well, my recollection of Mr. Sarbanes' response when I inquired yesterday of him was that he does not believe in the Madison theory or the,
no,
or the
he
Madison
didn't.
concept.
But he still was attempting to do it by his theory of the policy. Now, are you saying we're taking it out altogether?
Would the gentleman yield?
Well, wait, I'd like to see what Mr. Rails
my thrust, I guess, is to get away from the language of policy, and I think I've answered your question as far as my own beliefs about imputing criminal responsibility. I don't think I can answer it any more clearly. I don't believe in any kind of imputation of criminal responsibility, and I think that the President should be charged with direct acts or knowledge. I think there has to be some kind of presidential knowledge or involvement.
Well,
I just happen to think there is.
I thank the gentleman for his answers and reserve the balance of my time.
Chairman. The gentleman from Maine is recognized.
Chairman, perhaps I can add to Congressman Railsback's response, having discussed this matter with him at some length. I believe the word plan was used in his substitute because this is the exact language that the President used, referring to the transcripts of March 22nd, 1973, when there was a discussion between Mr. Mitchell and the President. You recall the words that up to now, our plan has been one of containment. And then there was additional reference to the fact that we're adopting a new plan now, and that new plan was going on to the use and implementation of executive privilege to be asserted for some of the aides going before the Senate Select Committee. Now, that is the reason I think that you incorporated the word plan. I yield back.
Mr. Wiggins seeking recognition?
Yes, Mr. Chairman. May I be recognized?
Gentleman is recognized.
Right. Thank you, Mr. Chairman. I have several questions which I'll be directing to my colleague, Mr. Railsback, about his amendment. I have it before me, and it seems to say, omitting the parenthetical expressions, that Richard Nixon engaged personally in a course of conduct or a plan designed to delay, impede, and do other acts in connection with an obstruction of justice charge. Now, I want to understand, does the word designed, as used in your amendment, Mr. Railback, mean that mean that the President intentionally and corruptly acted for the purpose of delaying, impeding, and so forth? Is that your intent?
Well, gentlemen,
of course.
I think that the design can relate to either the course of conduct or the word plan, and I think that it clearly means that the action that he took knowingly.
And to carry on, knowing the purpose of his acts, that is to obstruct, delay, hinder, and impede the due administration of justice.
My friend will yield. The answer is yes.
All right. Then that evidence, which may be before us, which suggests that the motivating purpose of presidential actions was to obstruct, delay, hinder, and impede, and so forth, would not be covered by the language of yours in this amendment. Is that so, Mr. Rails?
Well, let me make myself clear on that. If you're suggesting that the litany or the recital of events that was made by Mr. Walde yesterday, which referred to many acts about which we have no knowledge of direct presidential direction or involvement, the answer again is yes. I don't think there is frankly, a proper place to be considering things other than relate to the president. We're talking about the impeachment of the President of the United States. We're not talking about criminal indictments returned unless they happen to relate to his knowledge or to his direct involvement.
All right. Now, I think it would be a fair summary of the gentleman's position, and if I err, you're right here to correct me, that you intend by this language to put to the managers in the Senate the burden of proving that the President personally acted to corrupt the due administration of justice by intentionally engaging in a plan or design, a course of conduct or a plan which was intentionally designed to obstruct justice. Now, is that a fair statement?
What I intend by the amendment is to suggest that Richard M. Nixon, if it can be shown in the Senate, and if he can be held account in the Senate, that he used his powers of high office, engaged personally and through his subordinates and agents in a course of conduct or plan designed to delay, impede, and obstruct the investigation of such unlawful entry, to cover up, conceal, and protect those responsible, and to conceal the existence and scope of other unlawful covert activities. In other words, the words speak for themselves.
Okay. I understand. You mean what you said. Well, I'm running out of time. I want to clear up the question, however, of the conduct of his aides. In order to have this to be the President's acts, you would require, I am sure, that at least he have knowledge of the acts of his aides, or that he instructed them with the requisite corrupt intent to obstruct justice, would you not?
Mr. Chairman,
what?
Excuse me, I'm sorry.
I would answer the gentleman by saying the language still speaks for itself, but it is my belief that to hold Richard Nixon to account and to remove him from office, it must be proven that he has committed a serious offense, serious enough for which he should be removed from office. Now, if he directed something, or if he participated in something, or if he was involved in something that was clearly illicit, if he falsely misled the American people, or if he obstructed justice, or impeded justice, or interfered with the due administration of justice, or if he abused the power, such of the sensitive agencies as the IRS, well, then I think that's what he's going to be held to account for.
All right, fine. I appreciate the gentleman's explanation. I support the gentleman's amendment as explained.
I think I have a little time left if I may use it.
The chair will state that pursuant to the policy that was set, no member could reserve any time, but if the gentleman is seeking more time, he can request unanimous consent, which has already been recognized once.
I appreciate the chair. If I could have it, I would like to ask the gentleman from Maryland, Mr. Sarbanes, a question.
Oh, without objection.
Thank you, Mr. Chairman. I'd like to ask the gentleman this. Do you subscribe to Mr. Railsback's explanation of the meaning of his amendment as to responsibility of the President for third person's actions, or do you still feel that his amendment will support your own theory on that subject as announced by you yesterday?
Well, as I understood the last response which the gentleman from Illinois, Mr. Railsback, gave, I thought that was a proper elaboration of his amendment. As I understand it, part of what we've been discussing is this whole concept of the Madison superintendency theory, and I think this is very clear with respect to that proposition. That proposition is not contained in this article as a potential premise.
If I understand your answer, then you feel that Mr. Railsback's version comports very well with your own as advanced before the amendment.
Well, as I must confess to the gentleman from Indiana that I did not pay the close attention to the full colloquy between Mr. Railsback and Mr. Wiggins that I should have in order to respond definitively to the question that he's just put to me. And I apologize for that. But it is my impression that the last response which I heard Mr. Railsback give seemed to me a satisfactory elaboration of this amendment.
Well, I'm not sure whether the gentlemen are together or not, but if you are together with the gentleman from Illinois, or if he is together with you, why, since I didn't like your version very well before, I'm not persuaded that his is much different or much better.
The question is on the amendment offered by the gentleman from Illinois. All those in favor of the amendment, please signify by saying aye. All those opposed? No. The ayes appear to have it. The ayes have it, and the amendment is agreed to. The gentleman from Illinois.
Consider them in block.
A conforming.
Mr. Chairman, I have a
conforming
amendment, if I can find it.
Senate the burden of proving that the President personally acted to corrupt the due administration of justice by intentionally engaging in a plan or design, a course of conduct or a plan which was intentionally designed to obstruct justice. Now, is that a fair statement?
What I intend by the amendment is to suggest that Richard M. Nixon, if it can be shown in the Senate, and if he can be held account in the Senate, that he used his powers of high office, engaged personally and through his subordinates and agents in a course of conduct or plan design to delay, impede, and obstruct the investigation of such unlawful entry, to cover up, conceal, and protect those responsible, and to conceal the existence and scope of other unlawful covert activities. In other words, the words speak for themselves.
Okay. I understand. You mean what you said. Well, I'm running out of time. I want to clear up the question, however, of the conduct of his aides. In order to have this to be the President's acts, you would require, I am sure, that at least he have knowledge of the acts of his aides, or that he instructed them with the requisite corrupt intent to obstruct justice, would you not?
Mr. Chairman.
What?
Excuse me, I'm sorry.
I would answer the gentleman by saying the language still speaks for itself, but it is my belief that to hold Richard Nixon to account and to remove him from office, it must be proven that he has committed a serious offense, serious enough for which he should be removed from office. Now, if he directed something, or if he participated in something, or if he was involved in something that was clearly illicit, if he falsely misled the American people, or if he obstructed justice, or impeded justice, or interfered with the due administration of justice, or if he abused the power, such of the sensitive agencies as the IRS, well, then I think that's what he's going to be held to account for.
All right, fine. I appreciate the gentleman's explanation. I support the gentleman's amendment as explained.
I think I have a little time left if I may use it.
The chair will state that pursuant to the policy that was set, no member could reserve any time, but if the gentleman is seeking more time, he can request unanimous consent, since he's already been recognized once on the amendment.
I appreciate the chair. If I could have it, I would like to ask the gentleman from Maryland, Mr. Sarbanes, a question.
Without objection.
Thank you, Mr. Chairman. I'd like to ask the gentleman this. Do you subscribe to Mr. Railsback's explanation of the meaning of his amendment as to responsibility of the President for third person's actions, or do you still feel that his amendment will support your own theory on that subject as announced by you yesterday?
Well, as I understood the last response which the gentleman from Illinois, Mr. Railsback, gave, I thought that was a proper elaboration of his amendment. As I understand it, part of what we've been discussing is this whole concept of the Madison superintendency theory, and I think this is very clear with respect to that proposition. That proposition is not contained in this article as a potential premise.
If I understand your answer, then you feel that Mr. Railsback's version comports very well with your own as advanced before the amendment.
Well, as I must confess to the gentleman from Indiana that I did not pay the close attention to the full colloquy between Mr. Railsback and Mr. Wiggins that I should have in order to respond definitively to the question that he's just put to me. And I apologize for that. But it is my impression that the last response which I heard Mr. Railsback give seemed to me a satisfactory elaboration of this amendment.
Well, I'm not sure whether the gentlemen are together or not, but if you are together with the gentleman from Illinois, or if he is together with you, why, since I didn't like your version very well before, I'm not persuaded that his is much different or much better.
The question is on the amendment offered by the gentleman from Illinois. All those in favor of the amendment, please signify by saying aye. Aye. All those opposed? No. The ayes appear to have it. The ayes have it, and the amendment is agreed to. The gentleman from Illinois.
You should have considered them in block.
A conforming.
Mr. Chairman, I have a conforming amendment, if I can find it. Can it be read? The
Clerk will read the amendment.
On page 1, line 18 of the Sarbanes substitute, beginning at the third paragraph, strike out the following. The means used to implement this policy have included one or more of the following, and insert in lieu thereof the following new language. The means used to implement this course of conduct or plan included one or more of the following.
Mr. Chairman, I think the language speaks for itself, and I'm not going to belabor it.
The question is on the amendment offered by the gentleman. All those in favor, please say aye.
Aye.
All those opposed? The ayes have it, and the amendment is agreed to. I recognize.
The committee members are now voting on a series of amendments to the first proposed article of impeachment. In a moment, the congressmen will return to their debate over whether the first impeachment article is specific enough in spelling out the charges against the president. NPAC's videotape coverage of the House Judiciary Committee's impeachment debate will continue shortly.
This is PBS, the Public Broadcasting Service. Washington Week in Review analyzes the presidency.
Yeah, I think he does think the House will not impeach him. Now, you may think that's living in a world of self-delusion, but I think they genuinely believe that is not going to happen.
Washington Week in Review reports on the Congress.
It's becoming increasingly doubtful whether the Senate will have time this year to try the impeachment trial.
Washington Week in Review discusses foreign affairs.
Kissinger goes up and down in optimism and pessimism. I think that's clear. He saw a chance to get a deal, and he said he'd stay a few more days.
With moderator Paul Duke, Washington Week in Review looks at the major national and international events of the week. From Washington, NPACS, Washington Week in Review.
Evening at Pops is back. Arthur Fiedler and the Boston Pops Orchestra with guest stars for another wonderful summer of entertainment. Join us for an Evening at Pops.
NPAC's coverage of the House Judiciary Committee's impeachment debate continues.
As we go back to the hearings, Democrat Walter Flowers is about to move to strike another section from the first impeachment article.
I recognize the gentleman from Alabama, Mr. Flowers.
Thank you, Mr. Chairman. I have an amendment at the clerk's desk.
Clerk will read the amendment.
Do I understand, Mr. Flowers, that this is the amendment number 2 on the general list of amendments?
That's correct.
Strike subparagraph 2 of the Sarbanes substitute.
Mr. Chairman, I offer this amendment having no fear that I will be unable to explain what it means to any of my colleagues on the panel, and hoping that they fully understand what it means, and I'm certain they do. And I offer it not in any dilatory manner, but as a device to elicit from members of the panel or staff specifics of what charges, what information, what evidence do we have that would come under paragraph 2. Are we capable of proving satisfactorily, in a clear and convincing manner, the allegations of subparagraph 2, which is on page 2 of the Article 1 of the Sarbanes substitute. I think that the proof aspect of it is vitally important, and I think that the comments made last evening as to the notice that the President is entitled to, that this will likewise serve a vital function along those lines. So I make this motion to strike, and I ask staff, Mr. Dorr, or any member of the committee, I'm prepared to yield to them. It can provide me with evidence to support this allegation in subparagraph 2. I see Mr. Cohen. I yield for a question.
In all due respects, it should be the gentleman that has in his mind now the evidence. He shouldn't be seeking it from staff. We're about ready to vote, and you've indicated apparently a tendency to vote on what you have in your mind. Tell us what you're thinking about to justify this charge. Don't refer to staff. They don't have a vote.
I would remind the gentleman that I made a motion to strike the subparagraph, not in support of the subparagraph, and I yield to the gentleman from Maine.
I thank the gentleman for yielding and want to commend him for making this motion, as I will commend Mr. Sandman for making a similar motion last evening. I happen to share the belief that fundamental fairness requires that we articulate the operative facts upon which the House intends to rely on if and when it votes to take this matter to the Senate for trial. And I think Mr. Latter made an awfully impressive and important point last night by engaging in some demonstrative evidence when he stacked up those 8,000 or 9,000 pages of the documents that we've received during the past 6 months. Because if the House, I doubt whether the House members can read, digest, and comprehend that material within a period of 10 days, and we have an obligation to pinpoint, not only for the President, but on behalf of the members of this full House, the exact facts upon which we intend to rely. Pursuant to that, I think that the following factors should be included, and will be included under this particular subparagraph. That almost immediately after the Watergate break-in, information and evidence regarding illegal activities began flowing into the White House. Almost without any exception, this information was withheld from the investigators. Specifically, by June 19, 1972, John Ehrlichman, whom the President had placed in charge of investigating Watergate for the White House, had learned that Mr. Liddy was involved in that break-in and that it was a CRP, Committee to Re-elect operation. Mr. Haldeman, Mr. Mitchell, Mr. Mardian, Mr. LaRue were also aware of this information. Specifically, these facts were withheld from the Attorney General and other investigators. At the same time, Liddy was retained for well over a week as counsel to the Finance Committee to re-elect the President, even after Mr. Mitchell knew of his own involvement. Specifically, by June 20, 1972, important physical evidence had turned up within the White House relating to the break-in. These documents included materials relating to the Liddy plan, Mr. Segretti's activities, other political intelligence activities located in Mr. Haldeman's office and files, a White House telephone directory containing Howard Hunt's name and Hunt's employment records showing that Hunt was not terminated from the White House payroll officially. None of these documents were turned over to investigators. The memoranda from Haldeman's office were shredded. The telephone directory was changed, and the employment records were altered. On June 19th, I think it would be important to recall that the President spoke with Mr. Colson to determine what Hunt's status was. On June 20, we should also take and remind ourselves that a conversation was held between Mr. Haldeman and Mr. Haldeman and the President, during which they discussed the Watergate break-in, 18.5 minutes of which has been erased. On June 20, a phone call was placed by the President to Mr. Mitchell on a phone that was not hooked up to a tape recording system, but which the President dictated a memorandum to himself that evening. In that memorandum is contained the recitation by Mr. Mitchell that he apologized to the President for Watergate, saying he was sorry he had not better policed his men. Mitchell's acknowledgement that his men were involved was not passed on to investigators. And you'll recall that the President also had stated publicly that Mitchell's statement that there was no legal or ethical responsibility for the break-in in the White House or the Committee to Re-elect was endorsed as of June 22nd. Specifically, on June 23, 1972, Haldeman and Ehrlichman met at the President's direction with the head of the FBI and CIA, Patrick Gray and Vernon Walters. And despite the fact that Haldeman and Ehrlichman were aware that there was CRP involvement in the Watergate break-in, they did not tell this to Mr. Gray and Walters. Rather, they suggested that despite Helms's assurances that there was no CIA involvement, further FBI investigations of the Dahlberg and Ogario checks might uncover CIA activities. On June 28, 1972, Mr. Ehrlichman and Dean delivered certain documents from Mr. Hunt's safe to the FBI Director Gray. Specifically,
the gentleman has expired. The time of the gentleman from Alabama has expired.
Mr. Chairman.
Mr. Donohue.
I think the gentleman from Maine is making a very important statement, and therefore I yield whatever balance I have of my time to him.
The gentleman is recognized for 5 minutes.
Referring to June 28, Mr. Ehrlichman and Dean delivered certain documents from Hunt's safe to FBI Director Gray. They told him that although the White House wanted to say that it had turned everything from Hunt's safe over to the FBI, the documents, quote, should never see the light of day. And Gray later destroyed these documents. Specifically, on July 5, 1972, Mitchell was interviewed by FBI agents investigating the Watergate break-in. Although Mitchell has admitted that he had been told of Liddy's involvement, he did not give this information over to the agents. Specifically, John Dean reported to Haldeman and Ehrlichman that payments to the Watergate defendants during the summer of '72 were being made through Mr. Kalmbach, the President's personal attorney. Specifically, by the middle of September, Mr. Kalmbach had delivered $187,000 in cash to the defendants or their attorneys. During the summer of 1972, Mr. Dean and others in the White House were told of perjury and false statements by Magruder and Porter. This information was also withheld from proper investigative authorities. I also call your attention, Mr. Dorr, Mr. Jenner, and members of the committee, that on September 15, 1972, the President had a conversation with Mr. Dean, during which time he told Mr. Dean that he had done a good job in plugging the leaks that were springing up here and springing up there. Specifically, on March 13, 1973, the President was told that Mr. Strawn had lied to investigators. Specifically, the President, who bears the ultimate responsibility for the enforcement of our laws, did not report this to the Attorney General or to the Director of the FBI. On March 21, 1973, the President was told of perjury by Magruder and Porter before the Watergate grand jury. Specifically, the President did not direct, nor did he report this to the Attorney General or the Director of the FBI. Specifically, John Dean told the President of the complicity of his associates in the Watergate break-in and cover-up on March 21, 73. On March 22, 1973, the President telephoned Attorney General Kleindienst during the course of a meeting with Haldeman, Ehrlichman, Mitchell, and Dean. Specifically, the President only instructed Kleindienst to begin working with Senator Howard Baker for the President's positions with respect to the upcoming hearings before the Senate Select Committee. On March 23, 1973, and March 25, 1973, the President spoke by telephone with Attorney General Kleindienst. Specifically, the President did not disclose any of the relevant material information which he possessed with respect to the Watergate matter to the Attorney General at any time during the course of these conversations. On March 23, 1973, the President telephoned Acting Director L. Patrick Gray. Specifically, the President told Gray that he was aware of the beating that Gray had taken during the confirmation hearings, and he believed it to be unfair. Specifically, he reminded Gray that he had told Gray earlier to conduct a thorough, aggressive investigation. Specifically, the President did not tell Gray of the information he had received from Dean on March 21, 1973, or any of the other relevant and material information that he had in his possession. Specifically, once again, on April 15, 1973, the President met with Attorney General Kleindienst, who reported to the President that the prosecutors had evidence implicating Mr. Mitchell, Dean, Haldeman, Ehrlichman, Magruder, and Colson, and others in the Watergate matter. Specifically, the President did not tell Kleindienst that he had previously been given this information by Dean. Specifically, on April 15, 1973, the President met with Peterson, who further reported on the information the prosecutors had from Dean and Magruder. The President did not disclose to Peterson the information that Dean had discussed with the President on March 21, 1973. In addition, I would also point out to my colleagues that the President told Mr. Peterson to stay away from the break-in in Dr. Fielding's office because it was a matter of national security. On April 25th and 26, 1973, Mr. Haldeman listened to White House tapes to ascertain the contents of the March 21, 73 conversation among the President, Haldeman, and Dean. Neither the existence of these tapes nor the fact of Haldeman's having listened to them were ever revealed to proper investigating authorities, even though Mr. Haldeman was then a suspect and very much under investigation. Finally, between April 15, 73 and April 30, the President spoke on at least 27 occasions with Mr. Peterson regarding the Justice Department's Watergate investigation. The President did not inform Peterson of the White House taping system or any of the information he had received from White House officials regarding their criminal involvement in the Watergate matter.
Time of the gentleman.
Chairman. Mr. Chairman.
Massachusetts has expired.
Mr. Chairman.
Mr. Sandman is recognized.
Thank you, Mr. Chairman. I count on you the seconds, and may I say to my friend from Alabama, if you were to stand on your head and do the fanciest of tricks, you would have 12 votes, no more. And there is no point in the continuation of this kind of an argument. I agree with you with all my heart. But you're going to have a far better forum on another day. over in the House where we both sit. So please, let's not bore the American public with a rehashing of what we've heard. We went through this for many hours yesterday. And to those who favor keeping the Sarbanes substitute as it is, you've got 27 votes. Let's go on with our business. I yield back my time.
Mr. Chairman.
I recognize the gentleman from Maryland.
Mr. Chairman, it seems that my good friend from New Jersey, Mr. Sandman, is carrying water on both shoulders. And I say this kindly, he subjected all of us yesterday to belabored arguments about the need for specificity. Now, he convinced a number of us that he's right. We should have specificity. So what we're involved in now is not an effort to embellish or exaggerate the narrative material, which almost all of us are familiar with in a general way. We're trying to be responsible and specifically support every item in the articles of impeachment with not supposition, not rumor, but specific facts to support those charges. Now, I would have thought that the gentleman from New Jersey would applaud this effort. Because of his eloquence yesterday, he convinced us of the rightness of his arguments. So I'm very surprised now that he's saying that we're just wasting our time. I'll yield to both gentlemen from New Jersey, the gentleman from Sandman, whose name I used first.
Well, I'm certainly not carrying water on both shoulders. What you're doing today is not any more definitive today than it was yesterday, because you're not adding one blessed word of clarification to the articles of impeachment. All you're doing is rehashing the same narrative that the public was exposed to yesterday for a dozen hours. And this is what I think we should say of them.
Well, I would say to the gentleman that I think the presentation today is strikingly dissimilar to the statements made yesterday, to which I personally took exception. I think that we should stick specifically to the facts and the evidence, and I think that that's what has been evolving here today. And I will yield to my other friend from New Jersey, Mr. Mariziti.
Thank you, Mr. Hogan, for yielding. Let me say that Mr. Sandman has stated a position that I had intended to state, that the specific point is this, that what we have asked for and what he's asked for is including the allegations in the articles of impeachment. Now, we have a recitation of facts. It's all well and good. I have no objection to it. But I'm saying, I'm not talking about facts or evidence, I'm talking about allegations that ought to be included in the articles of impeachment. Not a recitation here. If you want the recitation here, fine. But if these are the allegations, put the allegations in the articles of impeachment, so we know what we're voting on, and so that the respondent knows how to defend.
I would say to my friend from New Jersey that he is free to offer amendments to the Sarbanes substitute or to the Donahue resolution, inserting in the kind of specificity, to use a much worn word, that he desires. We have advice from our expert counsel that it's not necessary. It is my own feeling that it's not necessary to have it in the impeachment resolution itself, although I do agree that we have a responsibility to shore up the allegations in the impeachment resolution with factual evidentiary material, and that's the effort in which we're now engaged.
Gentleman yield.
Gentleman yield.
I yield to the gentleman from Illinois, Mr. Railsback.
Mr. Dorr, I'm wondering if the staff, pursuant to our discussions yesterday, is preparing, in effect, what amounts to a bill of particulars, or?
Yes, we are, Mr. Congressman.
You are, and is that going to be? Are there going to be specific references to the items within each article?
Yes.
Well, then I'm inclined, frankly, Mr. Chairman, to agree with Mr. Sandman that perhaps this is all a waste of time. In other words, I think we do know how we're going to vote, and perhaps the bill of particulars, which I think is going to be submitted to us anyway, is it not? For our approval or disapproval?
Well, I don't know what plans the chairman has. This was, as I indicated yesterday, Mr. Congressman, that this would be included as part of the proposed report.
I thought Mr. Cohn did a fine job in laying out a lot of facts, and I thought it was an excellent presentation. I just wonder if perhaps this shouldn't be done in another way so that we can move along.
Mr. Chairman,
I think I'll yield to the gentleman from Indiana and then to the gentleman from Mississippi if I have any time remaining.
I thank the gentleman for yielding. I've really seeking recognition to speak on my own time on the amendment.
I'll yield to the gentleman from Mississippi then.
Well, I'll have one quick question then. Mr. Dole, when will we get this bill of particulars?
Well, Mr. Congressman, as I say, it was our idea that we would prepare this material as part of the proposed committee report, and it would be up to the committee as to how that would be handled.
The time of the gentleman from Maryland has expired.
Mr. Chairman.
The gentleman from Indiana.
Thank you, Mr. Chairman. Mr. Chairman and members of the committee, the parliamentary scenario we see today whereby all those who were against specificity yesterday want to recite it today, albeit not put it in the charges, is kind of interesting. But aside from that, it's sort of refreshing to talk a little bit about the facts. I listened carefully to my good friend from Maine, Mr. Cohen, and he says, for instance, by June 19th, Ehrlichman had learned that Liddy was involved. Did Ehrlichman tell the president he'd learned it? There's no evidence he ever did. Did Liddy tell the president? Certainly not. The gentleman says Mitchell had learned something. Did Mitchell tell the president what he had learned? No evidence of it whatsoever at that time. You don't get anything involving the president in the gentleman's recital till pretty far down the line. Now, the first thing you get about the president is the statement that he made on a dictabelt that McCord said he was sorry he hadn't disciplined his men better. Is that news? McCord was one of his men, and McCord was in jail. No, I won't yield right now. It was Mitchell. It was Mitchell. McCord was Mitchell's man. Mitchell knew McCord was arrested. He didn't have to reveal anything that wasn't in the newspapers. And we said he was sorry he hadn't disciplined the people. All we know is he may have been talking about McCord. There's no significance to that at all. Now, you talk about Deeb, you talk about Kalmbach, you talk about Mitchell, you talk about Ehrlichman. Where do you get the president? Let me ask you a question. Who had a motive to cover anything up when this happened? There isn't any evidence at all that the president knew anything about this Watergate break-in ahead of time. I think we're all pretty well agreed on that. Now it happens. Who has a motive to cover it up? The worst thing that can happen to the president is to lose an election, which by that time he knew he couldn't lose no matter what he did, because you gentlemen over there were going to hand it to him by McGovern being obviously the successful candidate by that time. So he didn't need to worry about that. But Ehrlichman had something to worry about because he was involved in the plumbers and he was involved in the Fielding break-in, and he knew if you started to look into Watergate and you found out that these boys had been in the plumbers and that they'd been out in California, it was likely to get back to him. Mitchell had something to worry about because he had known about the surveillance plans for the Democratic Committee and, according to some of the evidence, had okayed it ahead of time. Haldeman didn't have quite as much, but he too had something to worry about because he'd had these political reports and he had $350,000 there to play with, and he had some things to be concerned about. But at that point, the president really has nothing. So why should he be bothered to cover up? All right, you go down the line a little bit further. The president learns nothing till March 21st, or maybe a little bit on March 13th. Now it says he's talking to Peterson and he doesn't tell him what he learned on March 21st. Well, from April 6th on, the president and Peterson both knew that Dean's singing like a canary to the United States Attorney. That was understood between them, that he was the state's evidence. They were talking back and forth. Peterson says, don't fire him yet because I need this fella. I may want to give him immunity, and so on and so forth. So there wasn't any need for the president to tell Peterson anything about what Dean was saying. At that time, the U.S. attorney was getting everything Dean was saying. If you start talking about the facts, if you start pleading the facts, you can't hold any much intendment against the president except by taking the worst possible construction on everything that happens, when the law is that he's entitled to the benefit of the doubt. And that's probably one of the reasons why we haven't had more specificity. And remember, by April 30, all these wrongdoers are cleaned out of the White House and gone. And they've been prosecuted, and they're in jail, and some of them, and everybody goes up to the Senate and testifies, so forth and so on. And I'm real glad to begin to see, even if we can't have it put in the charge like any decent charge would, what we're going to be talking about on the floor and on down the line and in the Senate if you ever get it there, because the more you analyze it, the more you're going to find out how weak this case is on the facts.
The gentleman from Pennsylvania, Mr. Eilberg, is recognized.
Chairman, I've listened with great interest to the statement of the gentleman that was just made, and he talks again and repeatedly about the lack of direct evidence. He talks about circumstantial evidence and how vague it is, and I'd like to place on the record at this point some of the cases of direct evidence so that we have in one place a number of specific examples where there is direct evidence of the knowledge and participation by the President. Some of these have been repeated before, but I'll just take a few minutes to point them out. Specifically, Colson reported that on June 17th or June 18th, when the President first learned of the break-in, he threw an ashtray across the room. This is direct evidence that the President knew that either CRP or White House persons were involved. Specifically, on June 20th, after 3 days of constant activity by the President's principal assistants, Haldeman met with the President and discussed what the President thought should be done about the Watergate. Haldeman's sketchy notes show that the President decided that there should be an attack for diversion. This tape was intentionally destroyed. This is direct evidence that the President was involved. It is also evidence that he must have believed the tape was incriminating. Specifically, on June 20th, the President had a conversation with Mitchell. The President made a dictabelt of this conversation. This dictabelt, with the President's recollection, showed that the President knew that CRP had a relationship with the burglary. Mitchell apologized for not supervising his men and because the matter had not been handled properly. On June 20th, Mitchell issued a false press release denying any CRP involvement. The President, because of his conversation with Mitchell, had to know this to be false. Notwithstanding this fact, the President made a statement to the press which told the public that what John and Mitchell had said was true. This is direct evidence of the President's active participation and leadership. On June 30th, the President, Mitchell, and Haldeman had a conversation about why it made sense for Mitchell to resign. This conversation discloses that both Haldeman and the President believed that more things might surface in the Watergate, and now was the time for Mitchell to leave before they did. On July 6th, the President failed to make any inquiry into Pat Gray's warning that his aides were mortally wounding him. This is direct evidence of the President's unwillingness to have their cover-up activities brought to light. On July 8th, without any conceivable rational basis for doing so, he discussed with Ehrlichman on the beach in Key Biscayne whether clemency should be offered to the persons involved in the Watergate. This conversation can make no sense at all unless the President was involved in making decisions relating to concealment of the Watergate. On August 29th, the President made a false press release about the fact that both John Dean and Clark McGregor were making investigations, Dean at the White House and McGregor at CRP. No investigation had in fact been made of either organization. On September 15th, the President sent for John Dean and told him he had done a good job and gave him directions as to how to stop the Patent Committee from being effective. I could go on, Mr. Chairman, but these are just some of the cases where the President had direct knowledge, participation, and direction.
I recognize the Gentleman from California, Mr. Daniels.
Mr. Chairman, I oppose the motion to strike. I'm not going to rehash this long list of evidentiary matter which have been so ably presented and which I think we all know almost to the point of nauseam here. But I do want to respond again to the comments, the arguments of the distinguished gentleman from Indiana, Mr. Dennis, who seems to continually feel that there's no evidence that puts this conduct directly in the lap, in the mouth of President Richard M. Nixon. I respectfully suggest that if we'll just go to the President's own taped transcript of September 15, 1972, and I'm not going to read it. It's been read time and time again. But you will remember that talking with John Dean that afternoon when John Dean came back from the courthouse, he complimented John Dean on the fact that, up to that time at least, Dean had been very skillful. He'd put his fingers in the dikes. He'd stopped all the leaks. He'd held and contained the investigation to the 5 actual burglars and the 2 surrogate burglars, the leaders of that pack, Liddy and Hunt. Now, those were words coming out of the mouth of the President of the United States in the Oval Office, the seat of government. Can you tell me that he didn't know what he was talking about? If he did not, I do not yield.
If he
did not know what he was talking about, that in itself is an impeachable situation. He certainly ought to know what he's talking about when he uses that language. Let's go on, and I'm not going on to to March 21. On February 28, 1973, another transcript from the President. Dean and the President are talking. What are they talking about? The usual thing, the Watergate cover-up. Only this time it's money. Money. Spell it out loud. Just pronounce it by name, money. And we're talking about a lot of money here. They're talking about paying off these people who were not supposed to break, who are not supposed to explain their participation in the Watergate unlawful entry and in the cover-up that followed. And who are we talking about? Of course, the 4 Cubans, but in addition, McCord, and far more importantly, E. Howard Hunt. So what do they say? They're talking about Herb Kalmbach. And there was a much-used person, if I ever saw one. If anybody who heard his testimony didn't have his heart go out to him, a man who was used, abused from one end to the other. But Herb had been called in to raise the money for these burglars. And the President's a little bit worried. The L.A. Times has been running stories on Kalmbach and so forth, and his skin's getting a little thin, perhaps. But Dean said, no, Herb's tough now. He's ready. He's going to go through. He's hunkered down, and he's ready to handle it, so I'm not worried. And the President, oh, well, it'll be hard for him. This is the President. It'll be hard for him because it'll get out about Hunt. What'll get out about Hunt? What else was there except the payment up to that time of something like $200,000? The President says, I suppose the big thing is the financing transaction. They'll go after that. How the money got down to the Bank of Mexico and so forth, that kind of stuff. And, of course, Dean concurred. Now you're in February of 1973. This isn't March 21. You know, on March 21, the President admits, he was finally told all about it. On March 21, dawn broke. All at once he was told about Watergate. But here on February 28, through some type of prognostication, he's discussing the Hunt financing transaction in which his good friend and loyal friend of many years, Herb Kalmbach, was used to raise money. Let's move along a little ways. On March 21, and I'm not going to repeat this conversation, but on March 21, the President of the United States, speaking from the old Oval Office, tells Haldeman and John Dean that John had the right plan before the election. He contained it all, and now we got to have a new plan from here on out. That's March 21. And you say the President did not know what he was talking about? And then again, on March 22, just the next day, after having known about these activities since at least June 17th, and out of his own mouth, having known about them since September 15th, he's talking with whom? His chief executive officer for law enforcement, the Attorney General of the United States, Richard Nixon, the President, talking to the Attorney General of the United States, Mr. Kleindienst, and he didn't tell him one word about this illegal activity.
The gentleman from California has expired. Mr. Froelich.
Members of this committee, when we adjourned late last night, I thought we had some type of vague understanding that the proposers of the article of impeachment, members of the staff, and other interested committee members would get together and possibly, if necessary, take all day today to work out the specifics and the details in support of the sub-paragraphs of Article 1. But as is so often the case in this committee, the signals change as the moments go by, and this hasn't happened. But I understand now that there is a backup article, Mr. Dorr, or some specifications in back of these sub-paragraphs that has been prepared by staff and made available to certain members of this committee. Is that correct?
There is a backup material on some of the paragraphs. We're working on all of the paragraphs.
Well, when these articles are prepared, can they be made available to all members of this committee and to the minority staff so that responses can be prepared by those that want to prepare responses?
Certainly, these were prepared at the request of particular members and at the request of the chairman, and I presented them to the chairman. But certainly, it seems to me that this material should be available to all members of the committee. I think that would have no question about it.
Well, would you direct your staff to make those available to all members of the committee that want them and to the minority staff immediately?
Certainly I would.
Thank you.
I thank the gentleman for yielding. I've been quite interested in the various and repeated mentions of the ashtray being thrown across the room by the gentleman from California, Mr. Waldy, and now by the gentleman from Pennsylvania. So, Mr. Chairman, I may want to reserve a few minutes at some later time to offer an amendment to ensure that we include the President's throwing of an ashtray as an impeachable offense. I don't understand the significance of this ashtray and why it's being repeatedly mentioned. Now, I found the gentleman's statement from Maine most interesting and very informative. But there are several items as he went along that I feel can be rebutted. If I could have the advantage of having this material and the specifics, perhaps from Mr. Dorr, it would be very helpful so that we can debate the specifics and the points of being brought up in support of these various sections. I urge the committee staff to give us this opportunity. In many areas that were mentioned, I think, again, it's the aides actions that are being referred to, not the President's. So I want to reemphasize, again, the line has got to be drawn to the President, and we cannot impeach him on the basis of his aides' actions. I thank the gentleman from yielding.
Recognize the gentleman from Ohio, Mr. Seiberling.
Thank you, Mr. Chairman. I'm having a little trouble with the mechanics here. Mr. Chairman, last night, Mr. Froelich and I discussed his suggestion that at least the members of the committee have before them a set of memoranda prepared by the staff setting forth the precise evidence that the staff feels supports each one of the paragraphs of this article of impeachment. And I do think that that would be a very worthwhile thing, and I understand that the staff has not yet had an opportunity to put the evidence in a definitive form that subtends these specific paragraphs. And in lieu of that, the purpose of the discussion here is to get before us, for purposes of debate, the evidence that we believe, those who support this article believe supports the article, and that's the purpose of this discussion. Now, I'd just like to fill in a couple of items here that have been touched upon by the gentleman from Maine, the gentleman from California, but that it seems to me ought to be spelled out a little bit more. Reference was made to the fact that on June the 23rd, Mr. Haldeman and Mr. Ehrlichman met at the President's direction with the head of the FBI and the Deputy Director of the CIA, Patrick Gray and Vernon Walters. But I think that we ought to get a little more information before us on that point. Remember that the risk that the link between the Committee to Re-elect the President and the break-in burglars became more imminent a couple of days after the break-in. By June 22nd, Mr. Gray had informed Mr. Dean that the $100 bills had been already traced to Mr. Barker's bank account in Florida, and that Mr. Dahlberg and a Mr. Ogario in Mexico had been identified, and that the FBI planned to interview them. And on June 23rd, Mr. Dean reported this information to Mr. Haldeman, who immediately reported it to the President. So there's no doubt that the President knows about that. And it's also undisputed that on June 23rd, the President directed Mr. Haldeman and Mr. Ehrlichman to meet with Director Helms of the FBI and Mr. Walters and express White House concerns, and ask Mr. Walters to meet with Gray and communicate those concerns to him. Now, what were those concerns? Mr. Haldeman told Mr. Ehrlichman, who told Mr. Helms and Mr. Gray, that the FBI investigation was leading to important people, and that it was the President's wish, because an FBI investigation in Mexico might uncover CIA activities or assets, that Mr. Walters suggests to Mr. Gray that the FBI should not pursue the matter, especially into Mexico. Now, the facts are these, that Mr. Helms said that there was no FBI problem in Mexico, a CIA problem in Mexico, that it was not involved in this at all. And secondly, the fact is that Mr. Ehrlichman told Mr. Gray not to keep the investigation away from the CIA, but to limit it to the 5 men who had been arrested in the break-in. In other words, keep it away from the rest of the world. Now, immediately after the meeting with Mr. Haldeman and Mr. Ehrlichman, Mr. Walters met with Mr. Gray and expressed these concerns. And Mr. Gray agreed to hold up the FBI investigation into the Mexican connection. And that's where it stood for about another 10 days, until finally Mr. Walters came over to see Mr. Gray, because Mr. Gray had asked Mr. Walters to put it in writing. And at that point, the CIA said, we can't put it in writing. And Mr. Walters said that the CIA was being used, and so was the FBI. Now let's go on to later in the summer of 1972. During the summer of 1972, Mr. Dean and others were told by the FBI of the perjury and false statements of Mr. Magruder and Mr. Porter. Was this information given to the authorities? No. Why wasn't it? I think it's reasonable to infer that this was part of the containment plan that the President later congratulated Mr. Dean for.
The gentleman from Ohio has expired. Gentleman from California, Mr. Wiggins.
I thank the Chairman for yielding. The motion on the table is to strike the language of the Sarbanes substitute in subparagraph 2. That subparagraph is directed to the withholding of information by the President, and I shall direct my remarks to that subparagraph only. At the outset, Mr. Chairman, let's reflect of what happened just a few moments ago. I think that we have pinned down absolutely that we're talking about presidential misconduct and not the knowledge, the acts of others, unless they were known to the President. Much of the material recited to us in support of subparagraph 2 are not the acts of the President at all, but rather the acts of others. And I'm willing to concede that there's plenty of misdeeds by others, but unless we attribute them to the President by the evidence, they're not relevant to this case. The evidence of presidential action presidential knowledge commences on March the 21st.
But before I mention that, let's reflect about some withholding prior to that time. On September the 15th, John Dean was up to his elbows in money payments. We all know that to be a fact. Did he disclose anything about that to the President insofar as our evidence is concerned on the conversation of September the 15th? Did he give the President any information at that time upon which the President could act? And the answer is no. What about February the 28th? John Dean is deeply involved in a criminal conspiracy to obstruct justice, according to John Dean. But what did he tell the President, speaking of withholding, on the 28th day of February? Absolutely nothing. What about now, the 13th day of March, the next conversation with Dean? Well, there's one on the 7th, too. I won't march through these, but just simply emphasize that there was some withholding here. Withholding by John Dean of information in his possession from the President upon which the President might have acted had that information been conveyed to him. Now, I don't think I'm going to have the time, John, and I will if I do have the time. The conversation of the 21st has to be read in its totality, morning and afternoon, and the full context of those remarks have to be understood. I suggest to my colleagues that the clear thrust of the afternoon conversation was that all of this information had to be presented to a grand jury. That was a presidential decision. He has many comments indicating that that is his preferred course of action, inconsistent with the concept of withholding. On the 27th day of March, the President specifically sought out as an option the appointment of a special prosecutor to hear all of these factual allegations of John Dean. You recall he said, we'll let Judge Sirica appoint the special prosecutor and say, Judge, let's go. Those are the President's words. That option was rejected, not to cover up, but rather was rejected at the instance and request of Henry Peterson, who thought that it would cast unfairly upon the ability of the Department of Justice. You recall that on the 27th of March, or thereabouts, the President announced as his policy, inconsistent with this withholding concept, that everybody would go to the grand jury and testify fully without claiming any privilege. You recall that in the first week of April, when John Dean was contemplating going to the United States attorneys, the President's instruction to John Dean was, don't lie, John, tell the truth when you go before the U.S. attorneys. Now, that's an important event, ladies and gentlemen. Presidential direct knowledge that John Dean was going to tell his story and was in fact telling his story to the U.S. attorneys commencing in the first week in April. So was Magruder. Those facts were known to the President. Now, that's the truth. Thereafter, when the President is alleged to have withheld information from Henry Peterson, the head of the criminal division, he is withholding information, according to the argument, which Peterson knows already by reason of the revelations of John Dean and Magruder before the grand jury. In terms of withholding information, ladies and gentlemen, recall that this President made a special effort to get John Mitchell, the big enchilada, as it were, to come forward and testify freely, fully, and fairly before the grand jury.
The time of the gentleman has expired. The gentleman from California, Mr. Waldy.
Mr. Chairman, I yield such time as he may desire to Mr. Seibling.
Thank you. I'd like to respond to some of the points made by the distinguished gentleman from California, Mr. Wiggins. Mr. Wiggins mentioned that on March 13, Mr. Dean had informed the President about certain perjury that had been committed by Mr. Strawn. I don't think I need to read all the transcript, but I'd simply point out that Mr. Dean told the President that Mr. Strawn knew about Watergate, and yet he was, quote, tough as nails, and that he is going to go into the grand jury and say again that he's going to stonewall it, and say, I don't know anything about what you're talking about. He's already done it twice, as you know, Mr. Dean told the President. And the President says, yeah, I guess he should, shouldn't he, in the interest of why I suppose we can't call that justice, can we? How do you justify it? And Dean says, well, it's a personal loyalty with him. The President goes on and says, well, I'll be damned. Well, that's the problem in Bob's case, isn't it? It's not Bob Haldeman. It's not Chapin then, but Strawn, because Strawn worked for him, Haldeman. And the President says, who knew better, Magruder? And the Dean says, well, Magruder and Liddy. And the President says, I see. The other weak link for Bob is Magruder, too, he having hired him and so forth. Now, this is on the 13th, almost a week before the famous March 21 meeting. Did the President rise up in righteous indignation, as he should have, and said, well, I'm going to clean this out right now, haul them in here, and we'll get them on the carpet, and I'll have the Attorney General here, too? Mr. St. Clair asked us to consider what we'd do if we were in the President's shoes. Isn't that what any law-abiding chief executive ought to do? But he did nothing. Now, on the 21st, and I'm going to skip over that that later on, Mr. Dean told the President about the perjury of Magruder and Porter, and the President did nothing about that. But then we get to the 21st. Now, on the night of the 21st, after the two meetings with Mr. Dean, the President dictated his recollection of the events of the day, and he said that Dean, and on a dictabelt, and he said that Dean felt he was criminally liable for his action in, quote, taking care of the defendants. That's the President's own word. And that Magruder would bring Haldeman down if he felt he himself was to go down. And that if Hunt wasn't paid, he would say things that would be very detrimental to Colson. And that Mitchell was involved. Now, what did the President of the United States do the next day? Did he go to the Attorney General and tell him all this? No. He held a meeting with Mitchell, Dean, Haldeman, and Ehrlichman to discuss the very crimes that Mr. Dean had already implicated them in, and the purpose of the discussion was to discuss how to contain it. In fact, the President's last words were, after he criticized General Eisenhower because all he cared about was being clean, he said, but I don't look at it that way. That's the thing I'm really concerned with. We're going to protect our people if we can. Apparently, the Justice Department was not part of our people, because during the course of that meeting, he called the Attorney General, and did he tell him about these crimes that had been revealed about his close aides? No. He told the Attorney General to get working with Senator Baker for the President's position in the Irvin Committee hearings. Now, it just seems to me that if he really wanted to turn this matter over to the law authorities, the next day he would have taken that dictabelt, called in the Attorney General of the United States, handed it to him, and said, Mr. Attorney General, do your duty. But he did not do that. And I'd be interested, Mr. Wiggins, what you have to say about that.
Are you yielding to me?
I'll yield. Well, I can't yield. The gentleman from California has the time.
I move the previous question.
The question is on the motion. The amendment, the motion offered by the gentleman from Alabama to strike. All those in favor, please say aye. Aye. All those opposed? No. The noes appear to have it, and the noes have it, and the amendment is not agreed to. And the chair will recess until 4 o'clock.
While the committee tries to figure out a way to speed up this process, we're going to take a short break. INPAC's videotaped coverage of the House Judiciary Committee impeachment debate will continue shortly.
This is PBS, the Public Broadcasting Service.
Can you hear it? Sure you can. Sound familiar? Sure it does. Feel that tingle? Oh, tingles are good, especially Tingles Revisited. Here it comes, the great American Dream Machine. Re-originals of your favorites, as crisp and crunchy as the day they first came down the pike. I'm Marshall Efron, inviting you to hook up to the Great American Dream Machine. It'll make you feel good. The Great American Dream Machine.
Award-winning films from the Washington National Student Film Festival, as judged by Nicholas Ray and Stan Vanderbeek.
NPAC's coverage of the House Judiciary Committee's impeachment debate continues.
As we go back to the hearings, the debate is about to move to another paragraph of the cover-up charge.
Committee will come to order. I recognize the gentleman from Alabama, Mr. Flowers.
Thank you, Mr. Chairman. I have an amendment at the clerk's desk.
The clerk will read the amendment.
Amendment by Mr. Flowers. Strike subparagraph 3 of the Sarbanes substitute.
Before proceeding on this, I would ask unanimous consent that debate on this amendment be limited to 20 minutes, with the chair allocating 10 minutes to the proponents of the subparagraph and 10 minutes to those who oppose it.
Without objection, so ordered, and as the chair understands, the gentleman's proposition would mean that those who would seek to be recognized to speak in opposition to the amendment, whether they come from the minority side or the majority side, would be recognized as opponents or proponents, as the case might be.
That is my intention, Mr. Chairman.
And the chair will, without objection, proceed in that fashion. The gentleman is
Mr.
recognized.
Chairman, thank you for this, and thank the committee for this, so that we might expeditiously get along with the consideration. I have talked with the gentleman from Virginia, Mr. Butler, about this particular subparagraph, and I would yield to him at this time, as I believe he has some material to explain about it.
I thank the gentleman for yielding, Mr. Chairman. Specifically, we are concerned at the moment with subparagraph 3. You will recall that the Article 1 is directed to a course of conduct or plan designed by the President designed to obstruct justice, and that there is, in addition to that, a following paragraph which says the means used to implement this plan include one or more of the following. And this deals with paragraph 3 of the following, which concerns itself with approving, condoning, acquiescing in, and counseling witnesses with respect to the giving of false or misleading statements to lawfully authorized investigative officers and employees of the United States, and false or misleading testimony in duly instituted judicial and congressional proceedings. And I would address myself at this moment to some of the specifics supporting the above paragraph of the article. I am assisted in this regard by the staff which helped us in preparation of this memorandum, and which was mentioned this morning earlier by the gentleman from Wisconsin. Specifically, on or about June 28, 1972, Jeb Magruder met with CRP Director of Scheduling, Porter, and asked him to prepare false testimony concerning the purposes for which cash had been distributed to Liddy. On July 19 and 20, respectively, Porter and Magruder falsely told FBI agents that the funds obtained by Liddy from CRP were for legal intelligence gathering. Specifically, on August 10, Porter testified falsely before the Watergate grand jury as to the purpose of the $199,000 in cash paid to Liddy. Specifically, on August 18, Magruder, after discussing his false story about the Liddy money, testified falsely before the Watergate grand jury. Specifically, on September 12 and 13, Magruder met with Mitchell and Dean to plan a false story regarding certain meetings among Mitchell, Magruder, Dean, and Liddy in early 1972. Specifically, Magruder thereafter testified falsely about the meetings before the Watergate grand jury. Now, I would direct your attention to page 86 of our transcript of the testimony, in which it shows that on March 21, during his morning meeting with Dean, the President was told of the perjury by both Magruder and Porter. Dealing on top of page 87, the President says who, and this deals with something that preceded it. I won't burden you with that. It talks about Mitchell, and then Dean says, I don't know how much knowledge he, meaning Mitchell, actually had. I know that Magruder has perjured himself in the grand jury. I know that Porter has perjured himself in the grand jury. And the President says, Porter, who is that in effect? And he is one of Magruder's deputies. And the President says, yeah. And then on March 13, 1973, specifically on March 13, Dean told the President directly that Strawn's denial of prior knowledge of the Liddy plan was false, and that Strawn planned to stonewall again in the future. And I call your attention to page 70 of the transcript, of the prepared transcript for the committee. Dean, well, Chapin didn't know anything about Watergate. And the President, you don't think so? Dean, no, absolutely not. President, did Strawn? Dean, yes. President, he knew? Dean, yes. President, about the Watergate? Dean, yes. President, well then, Bob knew. He probably told Bob then. He may not have, he may not have. Dean, he was. He was judicious in what he relayed, but Strawn is as tough as nails. The President, what'll he say? Just go in and say he didn't know? Dean, he'll go in and stonewall it and say, I don't know anything about what you're talking about. He has already done it twice, as you know, in interviews. He has already done it twice, as you know, in interviews. President, yes, I guess he should, shouldn't he, in the interest of, well, I suppose we can't call that justice, can we? We can't call it unintelligible. Dean, well, President, the point is, how do you justify that? Dean, it's a personal loyalty with him. He doesn't want it any other way. He didn't have to be told. He didn't have to be asked. It just is something that he found is the way he wanted to handle the situation. President, but he knew. He knew about Watergate. Strawn did. I'm trying to express a question mark there. Strawn did, question mark. Dean, I'll be damned. President, I'll be damned. Well, that's the problem in Bob's case, isn't it? It's not Chapin then, but Strawn, because Strawn worked with him. Says Dean.
Consume 5 minutes.
Mr. Chairman, may I have 5 minutes to speak in opposition to the motion?
I thought the gentleman was speaking in opposition to the motion.
I thought I was on Mr. Flowers' time, and he's the proponent of the motion, but Mr. Chairman, I will take my 5 minutes wherever I may, but I would
The gentleman, if the gentleman is seeking 5 more minutes, gentleman will be recognized for the 5 minutes, and that will consume the 10 minutes in opposition to the amendment.
Well, we'll have to live with that, Mr. Chairman. Returning now, if I may, I would like to emphasize that the procedural aspects of this proceeding are not without their levity. But I consider this an extremely serious matter, and there is indeed extensive evidence which I would, given the time, enlarge upon. I am going through my prepared remarks, and I will conclude, and I will let you know when my time has run out. But it goes on for, at this moment, some 13 pages, and it extensively develops with specific, whatever that word is, the point which this paragraph is addressed to, the approving, the condoning, the acquiescing in, and the counseling of witnesses with respect to false testimony. It is a grave matter, and I regret that we have chosen to limit the time, but I will do what I can with what I have. Specifically, on March 21, the President was instructed Dean and Haldeman to lie about the arrangements for payments to the defendants. In this regard, I call your attention to page 119 of the transcript. I think this is, we've probably been over this some little time before, but it's relevant to this particular point. Dealing with the Cuban Committee. As far as what happened up to this time, our cover there is just going to be the Cuban Committee, said the President, to do this for them up through the election. Dean, well, yeah, we can put that together. That isn't, of course, quite the way it happened. President, I know, but it's the way it's going to have to happen. Dean, it's going to have to happen. And I direct your attention also to page 120 of the transcript, which follows. Specifically on March 21st, also, the President told Haldeman and Dean, I can't recall. To say I can't recall if called before a grand jury. Specifically, Dean warned that there was a high risk of a perjury situation. The President, now this is on page 120 of the transcript. I think I will not burden you too much with that at the moment because I'm running out of time. Specifically, the President discussed how Magruder's perjury problem was helpful in making him keep his story straight, and that's on page 123 of our transcripts. The Dean says, Mr. President, once we start down any route that involves the criminal justice system, President, yeah. Dean, you've got to have a full appreciation of there is really no way to control that. President, no, sir. Dean, well, while we did, we had an amazing job of, yeah, I know, Dean, keeping the thing on the track before the President straight. Dean, while the FBI was out there, all that, and that was only because, President, right, Dean, I had unintelligible of where they were going. President, right, but you haven't got that now because everybody else is going to have a lawyer. Let's take the new grand jury, and that's the discussion they were having, if you recall. The new grand jury won't call Magruder again, wouldn't it? Dean, but based on what information it would. For example, what happens if Dean goes in and gives a story, you know, that here is the way it all came about? It was supposed to be a legitimate operation, and it obviously got off the track. I heard of these horribles, told Haldeman, that we shouldn't be involved in. President, yeah, right. Dean, then Magruder's going to have to be called in and questioned about all those meetings again and the like. And it begins to, again, he'll begin to change his story as to what he told the grand jury the last time. President, well, Dean, that's way he's in a perjury situation. Haldeman, except that's the best leverage you've got on Jeb, is that he's got to keep his story straight or he's in real trouble. Dean, that's right. And, of course, this conversation was between the President and Dean and Haldeman. Specifically, at the March 27th meeting between the President, Haldeman, and Ehrlichman, the following discussion took place. And this comes from the unedited or edited transcripts which have come to us from the White House, and I refer you to page 350 of that transcript, if you will. Haldeman, let's go another one. So you persuade Magruder that his present approach is not true. A, not true. I think you can probably persuade him of that. And B, not desirable to take. So then he says in despair, heck, what do I do? Here's McCord out here accusing me. McCord has flatly accused me of perjury. He's flatly accusing Dean of complicity. Dean is going to go, and Magruder knows of the fact that Dean wasn't involved, so he knows that when Dean goes down, Dean can testify as an honest man. President, is Dean going to finger Magruder? Haldeman, no, sir. President, there's the other point. Haldeman, Dean will not finger Magruder, but Dean can't either. Likewise, he can't defend Magruder. President, well, Haldeman, Dean won't consider unintelligible Magruder.
Gentleman, finish his sentence.
Finish his
sentence.
Well, I will finish what I was reading of the statement by Mr. Haldeman in this quotation, if I may. But Magruder then says, look, if Dean goes down to the grand jury and clears himself with no evidence against him except McCord's statement, which won't hold up, it isn't true. Now I go to the grand jury because obviously they are going to call me back, and I go to defend myself against McCord's statement, which I know is true. Now I have a little tougher problem than Dean has. You're saying to me, don't make up a new lie to cover the old lie. What would you recommend that I do? Stay with the old lie and hope I will come out, or clean myself up and go to jail? President to Haldeman, what would you advise him?
Time of the gentleman again has expired. The chair now recognizes gentleman from California to speak in support of the motion.
Thank you, Mr. Chairman. We have to start from an understanding of what the language is before us to be stricken. And I want to read the operative words at least. These are charges against the President, mind you, approving, condoning, acquiescing in, and counseling witnesses with respect to the giving false or misleading statements to lawfully authorized investigative officers and so forth, including congressional proceedings. Note, if you will, that the language is couched in terms of giving false testimony in the future. That's an important thing to remember, because the perjury of Magruder and Porter occurred prior to March 17, well prior to March 17, and the President didn't learn about it until March 17. And so I ask the obvious question, can you counsel the giving of perjured testimony after it's already done? Well, the answer to that is no. The President's just learning about it on the 17th.
There's the other point. Haldeman. Dean will not finger Magruder, but Dean can't either. Likewise, he can't defend Magruder. President. Well, Haldeman. Dean won't consider unintelligible Magruder.
Gentleman, finish his sentence.
Finish
his sentence.
Well, I will finish what I was reading of the statement by Mr. Haldeman in this quotation, if I may. But Magruder then says, look, if Dean goes down to the grand jury and clears himself with no evidence against him except McCord's statement, which won't hold up, it isn't true. Now I go to the grand jury because obviously they are going to call me back, and I go to defend myself against McCord's statement, which I know is true. Now I have a little tougher problem than Dean has. You're saying to me, don't make up a new lie to cover the old lie. What would you recommend that I do? Stay with the old lie and hope I will come out, or clean myself up and go to jail? President to Haldeman, what would you advise him?
Time of the gentleman again has expired. The chair now recognizes gentleman from California to speak in support of the motion.
Thank you, Mr. Chairman. We have to start from an understanding of what the language is before us to be stricken. And I want to read the operative words at least. These are charges against the President, mind you, approving, condoning, acquiescing in, and counseling witnesses with respect to the giving false or misleading statements to lawfully authorized investigative officers, and so forth, including congressional proceedings. Note, if you will, that the language is couched in terms of giving false testimony in the future. That's an important thing to remember, because the perjury of Magruder and Porter occurred prior to March 17, well prior to March 17, and the President didn't learn about it until March 17. And so I ask the obvious question, can you counsel the giving of perjured testimony after it's already done? Well, the answer to that is no. The President's just learning about it on the 17th, and a fair reading of the conversation between the President and John Dean on that occasion, my recollection is it's the 13th rather than the 17th, but on that occasion, is that the President is learning about prior perjury as distinguished from counseling future perjury, which is the essence of the allegation before us. In addition to that, my good friend has just read several statements from the transcript of March 21, in which John Dean is speaking to the President and the President to Don Dean about certain aspects of the then unfolding Watergate case. The question is, which we have to decide, and to decide on the basis of the evidence, convinced as we must be that it is clear and convincing, whether the President counseled anybody, advised anybody to go before a duly constituted investigative agency and not tell the truth. Well, now, I can only submit the record to you, ladies and gentlemen, and ask that you read it again, those specific incidences called to our attention by Mr. Butler, and ask that you read it fairly and resolve that question. Did the President indeed counsel anybody to commit perjury? Well, I can only say that I am satisfied, and I hope that you will be satisfied upon a rereading of that record, that the allegation is not true. There are other aspects, however, to this case which have been mentioned from time to time in the context of the President counseling false testimony. You will recall, ladies and gentlemen, that there came a time in the course of this testimony when we learned that the President advised various witnesses about what other witnesses were testifying to before grand juries, the assumption being that he was counseling them to phony up a story to counter the testimony which was then being received. I'm talking specifically about Herb Kalmbach, and you're well aware of that situation, Tom. I'm also talking specifically about Magruder. The backdrop, of course, was that John Dean was then testifying before the U.S. attorneys. Magruder, strike that, LaRue, now a broken man, was offering testimony before the U.S. attorneys. The president said that others have to be advised as to that testimony, the implication being that they would concoct a story to lie. Well, let me, within my remaining moments, say that there are not less than two reasonable constructions to be drawn from that. One is that they pony up a story to lie. Another, however, is that they not lie, that they conform their story with that being offered before the U.S. attorneys so as to avoid a perjury situation, even unintentionally. The notion that someone should be advised about the context of someone else's testimony is wholly consistent, ladies and gentlemen, with developing the truth, and is totally unfair, I believe, to suggest that that was part and parcel of a plot to develop the untruth. Now, we know here, as the lawyers for the House, that if you have these two reasonable possibilities, and I suggest that they are eminently reasonable, if you have these two reasonable possibilities, we must resolve that in favor of the President of the United States, the respondent, and not draw the adverse inference simply because some amongst us are relatively suspicious as to whatever the President does. One final comment, and then I think my 5 minutes are up. And that, are they up now?
Time of the gentleman has
expired.
Expired.
Thank you, Mr. Chairman.
Mr. Chairman?
Mr. Hutchinson.
I will yield additional time to Mr. Wiggins.
Thank you, Mr.
Gentleman is recognized.
I only wish to make one point because it's been discussed elsewhere, and that is Mr. Haldeman had the opportunity to review tapes prior to his testimony. That time, Mr. Haldeman and the President and a very few others were aware of this taping system. But Mr. Haldeman reviewed these tapes. The implication is being placed in the minds of the committee that this was, again, part and parcel of a corrupt design so that Haldeman could tailor his testimony falsely before a grand jury. Now, that's a suspicion alone. But let me tell you that there's another side that I think is equally defensible, and that is that Mr. Haldeman reviewed that tape so as to testify truthfully to the events thereon rather than falsely. I think that is an eminently reasonable conclusion, inconsistent with this suspicious circumstance, and the President is entitled to the more favorable construction of that event. I merely wanted to make that observation with respect to listening to the tapes, and I thank the gentleman from Michigan for permitting me to amplify it.
Does the gentleman from Indiana desire to be recognized on this question? I'd be happy to yield to the gentleman from Indiana.
I'll say to the gentleman from Michigan that I think my friend from California has very adequately covered this matter, and I don't really think I have anything particular to add. I'll yield time to him if he has anything else he wants to say.
Would the gentleman yield?
The question is on the motion of the gentleman from Alabama. All those in favor of the motion, please signify by saying aye. All those no. And all those in favor of the motion, please signify by saying aye. Aye. All those opposed? No. The noes appear to have it. The gentleman from New Jersey demands a roll call vote, and clerk will call the roll. All those in favor of the motion, please signify by saying aye. All those opposed, no.
Mr. Donahue?
No.
Mr. Brooks?
No.
Mr. Kastenmeier?
No.
Mr. Edwards?
No.
Mr. Hungate?
No.
Mr. Conyers?
No.
Mr. Eilberg?
No.
Mr. Walde.
No.
Mr. Flowers.
Present.
Mr. Mann.
No.
Mr. Sarbanes.
No.
Mr. Seiberling.
No.
Mr. Danielson.
No.
Mr. Greinen.
No.
Mr. Rangel.
No.
Miss Jordan.
No.
Mr. Thornton.
No.
Miss Holtzman.
No.
Mr. Owens.
No.
Mr. Mezvinsky.
No.
Mr. Hutchinson.
Aye.
Mr. McClory.
Aye.
Mr. Smith.
Aye.
Mr. Sandman.
Aye.
Mr. Railsback.
No.
Mr. Wiggins.
Aye.
Mr. Dennis.
Mr. Chairman, I'm quite puzzled when the author of the amendment votes present. I hardly know what to do, but I'll vote aye. Oh, I do that.
Mr. Dennis votes aye. Mr. Fish.
No.
Mr. Maine. Mr. Hogan.
No.
Mr. Butler.
No.
Mr. Cohen.
No.
Mr. Lott.
Aye.
Mr. Fraley.
Aye.
Mr. Moorhead.
Aye.
Mr. Marizidi.
Aye.
Mr. Latta.
Aye.
Mr. Rodino.
No.
Mr. Chairman,
Clerk will report.
12 members have voted aye. 25 members have voted no. 1 member has voted present.
And the motion is not agreed to. The gentleman from Alabama. Clerk will read the amendment.
Amendment by Mr. Flowers. Strike subparagraph 4 of the Sarbanes substitute.
Mr. Chairman, I'd like to make a motion that the debate on my amendment be limited to 20 minutes, to be divided 10 minutes to the proponents of the motion and 10 minutes to those that oppose the motion. I ask unanimous consent.
Without objection, and the policy will accordingly be the same, that the 20 minutes will be divided among the proponents and the opponents evenly.
Thank you, Mr. Chairman. I have discussed at length this subparagraph with the gentleman from Maryland, Mr. Hogan, and I would yield my time to him.
I thank the gentleman from Alabama. As we know, the paragraph reads, interfering or endeavoring to interfere with the conduct of investigations by the Department of Justice of the United States, the Federal Bureau of Investigation, and the Office of Watergate Special Prosecution Force. Now, perhaps I feel the importance of this more than most because of my former affiliation with the FBI, but the fact that the President and the White House used the FBI and the CIA to thwart the investigation troubles me very deeply, because if we don't have confidence in these important, sensitive investigative agencies, then the very core of our country is in jeopardy. So I'm going to be very specific, and my colleagues, if they so desire, can have from me later citations in the evidentiary record to substantiate the comments which I'm going to make. On June 21, 1972, Ehrlichman told acting FBI Director FBI Director Gray that Dean would be handling an inquiry into Watergate for the White House. The following day, the 22nd of June, Gray informed Dean that the $100 bills found on the Watergate burglars had been traced to the Miami bank account of Bernard Barker, who, as you'll recall, is one of the burglars, and that Dahlberg and Aguerrio had been identified as the makers of the checks and that the FBI was trying to locate these men for interview. The following day, Dean reported this information to Haldeman, and Haldeman reported it to the President. We subpoenaed a tape of the conversation between the President and Mr. Haldeman, and it was not given to us. But we do know from other testimony that the same day, the President personally directed Haldeman and Ehrlichman to meet with CIA Director Helms and Deputy CIA Director Walters to express White House concerns and ask Walters to meet with FBI Director Gray and communicate these White House concerns to Gray. They did meet with Helms. And Helms told Ehrlichman and Haldeman that there was no CIA involvement in the Watergate break-in. And he told him that he had previously given similar assurances to Mr. Gray. Haldeman told Helms that the FBI investigation was leading to important people, and it was the President's wish, because an FBI investigation in Mexico might uncover CIA activities or assets, that Walters suggest to Gray that it was not advantageous to pursue the inquiry, especially into Mexico. Ehrlichman's testimony subsequently was that the Mexican checks traced to this Florida bank account were discussed as a specific example of the President's concern. Now, why were they concerned about these checks? They were concerned because these checks were a direct link from the burglars to the committee to re-elect the President. And if that link had not been forged, we would not be sitting here today. So that's why they didn't want the investigation to go forward into Mexico. During or shortly after the meeting between Ehrlichman, Haldeman, Helms, and Walters, John Dean called Gray and told him that he could expect a call from Deputy CIA Director Walters. Immediately after the meeting with Haldeman and Ehrlichman, Walters met with Gray and expressed these so-called concerns. So Gray agreed to hold up the FBI interview of Aguirre, and he indicated that the FBI, however, was still going to try to locate Dahlberg. Parenthetically, at this very time, Dahlberg was meeting with Maurice Stans at the committee to re-elect the President, while the FBI was trying to find him. Walters, thinking that there might possibly be some CIA involvement of which he wasn't personally aware, checked his operatives in the field and to see if there was any jeopardy to CIA activities. He found out from them that there was no such jeopardy involved. On June 26, 1972, Walters so advised White House liaison man John Dean. On the 27th of June, Helms officially notified Gray that the CIA had no interest in Aguirre. And Helms and Gray, in their telephone conversation, set up a meeting for the following day so the two of them could discuss the question of possible CIA interest in Watergate. Mr. Gray reported this to Dean.
5 minutes.
Mr.
Gentleman's time has expired.
I seek 5 minutes recognition of my own time.
The gentleman is recognized. However, the chair would like to state that since the gentleman is speaking in opposition to the amendment, and there were others who sought to be recognized, would the gentleman be ready to yield 2 minutes to two other gentlemen? Otherwise, the chair is not going to be able to recognize them within that time.
I'll be very pleased to do so, Mr. Chairman. If the chair would advise me at that point in the expiration of my time, I'll conclude in mid-sentence and yield. May I continue?
Gentleman is recognized.
Mr. Gray reported this fact to Mr. Dean, that he was going to have a meeting with Helms. So on the morning of the 28th, Ehrlichman telephoned Gray and told him to cancel the meeting with Helms because he didn't want the meeting to take place at which Helms would tell him there was no CIA involvement. Gray canceled the meeting. The same day, Gray instructed his FBI agents to go out and interview Aguirre and continue to try to locate Dahlberg. Also on the 28th, Dean asked Walters if, even after knowing that there was no CIA involvement, Dean asked Walters if the CIA could stop the FBI investigations of the Dahlberg and Aguirre checks. Walters refused to do so. Since he couldn't use CIA to block the investigation, Dean then acted directly, called Gray, and insisted that for national security reasons or because of CIA interest, that Gray's instructions to interview those two men should be withdrawn. Gray did cancel the interviews. But a few days later, Gray called Walters and said he would interview them unless CIA put into writing its objection. CIA refused to do so, and Walters sent Gray a memo saying that CIA had absolutely no interest. They both expressed their dissatisfaction with the way the White House was interfering with their agencies and their concern that the President's interests were not being served by his aides. Now, these above activities were set in motion by the President and limited the investigatory efforts of the FBI. Now, there are other problems I was going to detail, but I won't be able to. But I do want to call to the attention and recollection of my colleagues the conversation whereby Gray called San Clemente and got Clark McGregor on the phone, and he said to Clark McGregor, "I want to talk to the President about his aides trying to misuse," these are Gray's words, not ours, "misuse the CIA and the FBI." A few minutes later, the President called Mr. Gray and didn't in any way allude to any conversation that he had had with Mr. McGregor or Mr. Gray's concern, and he congratulated Mr. Gray for doing an outstanding job in the hijacking. Mr. Gray couldn't contain himself anymore. He blurted out, "Mr. President, your aides are trying to destroy you. They are misusing the FBI and the CIA." And then Mr. Gray testifies, there was a perceptible pause, and the President said, "Go on with your aggressive investigation, Pat." He didn't even inquire about this involvement of his aides trying to misuse the FBI and the CIA. I only wish I had another hour to detail more specifics in this area, but unfortunately I do not, and I'll yield to the gentleman from California, Mr. Danielson.
Mr. Chairman, at this point I wish to save time, but in support of my amendment to include congressional committees, I wish to refer to and by this reference incorporate the comments I made this morning at the time of the amendment, and also my comments made on the day before yesterday, July 25, with respect to the House Committee on Banking and Currency. There's further evidence in support of such activities with respect to the Senate Select Committee and this committee, and I also incorporate them by reference. Shortage of time, I yield on to my brother, Father Dryden.
Thank you very much. Thank you very much. I want to point out the necessity of retaining this section because it deals with something very fundamental, that by federal law, any person who influences or seeks to influence or intimidates or impedes any witness in any proceeding commits a crime. Let's take the summer of John Dean during that particular year. On June 21, he's assigned to this case, and he sits, first of all, with Mr. Gray and the FBI people at every single interview when people from the White House go before the FBI. Is Mr. Dean seeking to influence or intimidate or impede? He happens to be the President's counsel. And all of the people who saw Dean there, who knew, recognize that this is most unusual, especially after the President, on the very day after Mr. Dean was assigned, so that the White House has had no involvement whatsoever in Watergate. And the President's counsel is there on the phone day after day for 2 long weeks with Mr. Patrick Gray. Well, Dean and Ehrlichman really could write a book on how to be a double agent in the FBI. Did he succeed in influencing? That's not the question. The offense is done even if he endeavors to influence. Mr. Dean was before this committee. I can't imagine him intimidating anyone, but he can influence and he can impede, and he was very successful.
Time of the gentleman from Massachusetts has expired. All time has expired, and the question is on the motion of the...
No, speak against it.
Oh, the chair did not intentionally overlook the minority side. I don't know whether it was subconscious, but nonetheless. I yield to... I recognize the gentleman from New Jersey, Mr. Sadman.
Thank you.
I sure didn't want to be counted out without a shot here. The thing that amuses me the most today, what a difference 24 hours makes. Yesterday they had so much testimony they were afraid to put it in 9 simple sentences. Now today, every other word they breathe is a word specific. Isn't that unusual? So unusual. Everything is so specific, but they haven't changed one word in the articles, have they? Not a word. There's got to be a reason for this resistance. There's got to be a reason. You know what the reason is. When you tame it down to a time and a place and an activity, they don't have it. All they have is conjecture. They can tell you all about what Dean told somebody, what Ehrlichman told somebody, what somebody else told somebody. This is going to be the most unusual case in the history of man. They're going to prove the whole case against the President of the United States over in the Senate with tapes and no witnesses. Won't that be unusual? And this is what it all amounts to. Now, if I went through this thing paragraph by paragraph, I could cite with great detail no presidential involvement. They know it, you know it, and I know it. Now, let's get down to a couple of these things. Real specifics. Will we ever forget Peterson's answer to my question, the most daring question asked in the whole investigation to the chief of the criminal division of the Department of Justice? When I asked Mr. Peterson, did you receive any information whatever from the very beginning up to the present time that involves presidential wrongdoing? That was a dangerous question. And Mr. Peterson's answer was none. That's a pretty solid witness, I would say, for the president. If you go right down the list of all 9 witnesses that came before this committee, including the great John Dean, you get the same kind of testimony. So witnesses are a lot stronger than this stuff that you're hearing here tonight. You can take it out of context. You can play up a particular article. You can do as Newsweek did, use only half of a sentence and leave off the 5 most important words. It's terrible, sure it is. But you and I know as lawyers, it's not the kind of evidence that's going to convict anybody. Now, there was such a cover-up here, so much of an interference between the president and his people. Isn't it unusual that not in a single case did the president ask for immunity for any of them? In fact, his move was to the contrary. He didn't want any of them to have any immunity. He wanted them to tell the truth, and he told every one of them, tell the truth. And it's replete in this testimony that he said that. We can say all we want about these various things. John Dean, a man who had a mechanical memory. He could remember split seconds of what he was doing 2.5 years ago, almost consistently. But he couldn't remember what was in the papers that he burned up. The only thing he couldn't remember. And then when Hunt was involved in this thing and Hunt's safe was drilled, sounds like somebody did something they shouldn't, doesn't it? Well, what happened? John Dean was told to take all of that stuff down to the FBI. He was told to do that. And he took everything down to the FBI except the 2 notebooks that involved him and had information in that he said he couldn't remember what they said. The Patman Commission. This is the joke of the century. You know, when you pick on a big man, everybody gets in the act. You can see what's happened here. And so it was with Mr. Patman. He had as much business involving himself in this case as anyone in the audience did. In fact, he tried a one-man investigation. You heard a little bit about that. And it was so bad that even the Democrats on that committee, which is a standing committee of the House, voted against his right to subpoena a single witness. That's the kind of jurisdiction Mr. Patman had. So there wasn't any interference here that meant anything. And we can go right on down the list. But let us get back again to the most important thing of them all. Why are these people resisting so hard to give us 9 simple sentences? Why? They don't have to give us great big volumes. They don't have to give us 150 pages that Mr. Dorr referred to. Just give us 9 simple sentences. Simple reason why they won't. They don't have the proof. They've got 40 books, but no witnesses. An unusual case, to say the least. Now, we can talk about this as long as we want, but I think we've talked long enough. I will yield the balance of my time to the gentleman from California, or Mississippi, I'm sorry.
Mr. Salmon, just a couple of points. First of all, with reference to this telephone conversation between the President and Pat Gray. The fact is, Pat Gray did not initiate that call. The President called Mr. Gray at approximately 8:25 a.m., July 6th. This all came about apparently through McGregor, and McGregor didn't meet with the President until 10 a.m. A lot has been said about what was said in that conversation. After Gray raised the question that the President's staff was trying to mortally wound the President, what did the President do? He paused perceptibly. And I think this is natural. It shows logically that there was a matter of first impression and concern. And he didn't make any kind of comments about cover-up. He told him, you just keep going right ahead with your thorough investigation, or some words to that effect. Now, there's no hard evidence that the President ever attempted to interfere with the course of the FBI's investigation. At no time did he, Haldeman, or Ehrlichman state that the investigation should be halted, and I refer you to Book 2, page 383. They merely expressed a concern, and a legitimate one, I think, at that time, that the trail not lead to exposure of CIA or plumbers' activities which would harm national interest. And this is important. Before and after that concern was expressed, there was no knowledge or no involvement by the President in the future attempts to limit the investigation. There's no evidence that the theory that Watergate break-in was a CIA operation was discussed before Gray told Dean the FBI was considering this possibility on June 22nd. Although Gray had checked with Helms before talking to Dean and received a tentative denial, it does not appear that he passed this information on to Dean. Refer you to Book 2, page 339. Therefore, there is no evidence that the President was aware of any CIA denial at the time he was informed of possible CIA involvement. Now, it's very difficult to argue to these specifics that we're being given. We hear them for the first time here, and there are replies to these, but we have to try to go and find the reply on the spur of the moment. It's important to differentiate, I think, between the President's expressed concern and the subsequent actions taken by his assistants without his knowledge. Once again, you must look at whether this is the assistants, the aides doing these things, or the President. I think Mr. Wiggins.
3.5 minutes remaining out of the 10 minutes. Mr. Wiggins is recognized.
Thank you, Mr. Chairman. I'll try to be succinct. It's instructive to remember, ladies and gentlemen, that in the form of this article, we're talking about presidential misconduct, and not the misconduct of others, unless it can be logically and appropriately tied to the President. I wish to speak rather rapidly to the matter of CIA. There are 2 presidential acts within the time frame of June 23 to July 6th, and that is the time frame in which it is alleged there has been interference with the CIA. The first act begins when the President issued these instructions as reported in our tab. The President instructed H.R. Haldeman and John Ehrlichman to ensure that the FBI investigation of Watergate didn't expose unrelated CIA covert activities or White House Special Investigative Unit activities, and that the CIA and the FBI should coordinate to this end. That's a presidential act, and it's admitted. The only other presidential act occurred on July 6th, several weeks later, and this is what the President said after being informed by Pat Gray that his aides are attempting to mortally wound the President. The President said, Pat, you just continue to conduct your aggressive investigation. Now, some sinister purpose is imputed because he paused briefly before he said that, but that's what he said. Now, I want to refresh the recollection of the members as to whether or not the President's concern about CIA was justified under all of the circumstances. We remember that McCord was in fact arrested and a former CIA agent. We remember that Barker was in fact arrested and a former CIA agent, perhaps an active CIA agent. Martinez was arrested and he was an active CIA agent. Hunt's name was in the Washington Post. Hunt was a spy for the United States, a former CIA agent, and a former member of the Plumbers Unit. There are other facts which were called to the President's attention on June 23, all of which indicate possible CIA involvement, a theory which was supported by the FBI itself. The FBI itself believed there might be CIA involvement. Given those facts, ladies and gentlemen, we are asked to conclude that the President corruptly instructed his aides to request that there be coordination between the CIA and the FBI so as not to reveal unrelated CIA covert activities. Now, ladies and gentlemen, that's all the evidence there is. In between the 23rd of June and the 6th of July, there's no question that John Dean acted improperly. I'm willing to stipulate to that. But that doesn't execute the President's instructions, which were given on the 23rd of June. On that issue, ladies and gentlemen, the question really isn't all that close. I would think that the weight, if not the preponderance of the evidence in favor of the President, is that he acted in the public interest as distinguished from corruptly. Surely, however, there is not a clear and convincing showing that the President acted corruptly, given the facts and the knowledge that he had at the time he issued the instruction. Thank you, Mr. Chairman.
Time of the gentleman has expired. All time has expired. And the question now occurs on the motion of the gentleman from Alabama. All those in favor of the motion, please say aye. Aye. All those opposed? No. The noes have it. The noes appear to have.
Roll call.
And the gentleman from New Jersey demands a roll call, and the clerk will call the roll. All those in favor of the motion, please signify by saying aye. All those opposed, no.
Mr. Donahue?
No.
Mr. Brooks?
No.
Mr. Kastenmeier?
No.
Mr. Edwards?
No.
Mr. Hungate?
No.
Mr. Conyers?
No.
Mr. Eilberg?
No.
Mr. Walde?
No.
Mr. Flowers?
Present.
Mr. Mann?
No.
Mr. Sarbanes?
No.
Mr. Seiberling?
No.
Mr. Danielson?
No.
Mr. Drynan?
No.
Mr. Rangel?
No.
Miss Jordan?
No.
Mr. Thornton?
No.
Ms. Holtzman?
No.
Mr. Owens?
No.
Mr. Mezvinsky?
No.
Mr. Hutchinson?
Aye.
Mr. McClory?
No.
Mr. Smith?
Aye.
Mr. Sandman?
Aye.
Mr. Railsback?
No.
Mr. Wiggins?
Aye.
Mr. Dennis?
Aye.
Mr. Fish?
No.
Mr. Maine?
Aye.
Mr. Hogan?
No.
Mr. Butler?
No.
Mr. Cohen?
No.
Mr. Lott?
Aye.
Mr. Fraley?
Aye.
Mr. Moorhead?
Aye.
Mr. Marizidi?
Aye.
Mr. Latta?
Aye.
Mr. Rodino?
No. Clerk will report.
Mr. Chairman, 11 members have voted aye, 26 members have voted no, 1 member voted present.
And the motion is not agreed to. I recognize the gentleman from Alabama. Mr. Flowers.
In a moment, the final amendments will be settled, and you'll see the first crucial vote on the first article of impeachment. NPAC's videotape coverage of the House impeachment debate will continue shortly.
This is PBS, the Public Broadcasting Service.
Sir Arthur Conan Doyle, I do believe. So sorry to have kept you waiting. Do please sit down. Thank you. And how's the great man?
I beg your pardon?
Mr. Sherlock Holmes.
Oh.
In good health, I trust. Likely to be on the scent again shortly. I suppose I should congratulate you on the ingenuity and cunning of your plots, even if they sometimes show up we professionals in a rather dim light.
Seems there's been an appalling miscarriage of justice.
Do you think he's innocent?
Well, somebody does, because he's just been released.
What reason was given?
None. Now, that's what intrigues me. The young lad sent for my help. I got onto the Home Office. They refused to answer.
When do I see you again, Mr. Holmes?
Oh, in a day or two. It won't take long.
Well, you will keep me informed.
Well, of course I will. You shall be Watson.
The ATP Summer Tennis Tour will attract world-famous players competing for top prize money. Stan Smith, Arthur Ashe, Marty Reeson, Chris Evert, Yvonne Goolagong, Rod Laver, and Bjorn Borg are just a few of the players you'll see in major tournaments, like the Canadian Open from Toronto, the U.S. Clay Court Championships from Indianapolis, and the U.S. Professional Championships from Boston. All great tennis, all on this station, all summer long.
Surface is like the skin of an apple. To disturb it is to destroy it.
NPAC's coverage of the House Judiciary Committee's impeachment debate continues.
As we go back to the debate, Democratic Congressman Walter Flowers of Alabama is again moving to strike out more charges against President Nixon, but only as a maneuver to spell out for the record what the charges entail.
Not agreed to. I recognize the gentleman from Alabama, Flowers.
Thank you, Mr. Chairman. I have an amendment to subparagraph 7 at the clerk's desk.
Amendment by Mr. Flowers. Strike subparagraph 7 of the Sarbanes substitute.
Mr. Chairman, there has been no motion filed on subparagraph 5 or 6 because it's my judgment that both of these subparagraphs have been adequately covered in other evidence presented to the committee here. And in connection with subparagraph 7, I would yield to the gentleman from New York, Mr. Rangel.
Thank you, Mr. Chairman. I rise in opposition.
The gentleman deferred. The gentleman from Alabama asked the same unanimous consent.
I regret that I passed over the most important thing. I ask unanimous consent that the debate on this motion of mine be limited to 20 minutes, with 10 minutes going to the proponents and 10 minutes to the opponents of the motion.
Without objection, it is so ordered. Gentleman from New York.
Thank you, Mr. Chairman. I rise to
to support this paragraph number 7, which deals with charging the President with disseminating information received from officers of the Department of Justice of the United States to subjects of the investigation conducted by lawfully authorized investigative officers and employees of the United States for the purpose of aiding and assisting such subjects in their attempts to avoid criminal liability. This is merely to suggest that one of the most sacred institutions that we have in this country is the proceedings which take place in the grand jury. It shocks my sensitivity to hear certain members of this committee indicate that an inference is drawn because the President shares information that he receives from the acting Attorney General with people that he knows are being investigated for possible indictment, where the acting Attorney General has indicated that these people would be indicted, that we can say that the President shared grand jury information with these people, that we should draw two inferences. One inference is that the President would want them to lie and conform their story to one that would avoid liability. And one of the members suggested that we should consider the fact that perhaps in this particular instance the President wanted one of his men to tell the truth. I submit that regardless of which one of these two the President was suggesting, it was violating the sacred information which should have remained in the grand jury and should never have been shared in the first instance with the President, and the President should never have used this information, regardless of for what purpose, to share with other people. This is especially so when he went out of his way to tell Henry Peterson that he was going to keep that information confidential. But this is all a part of a plan. Most of you recall on March the 21st when John Dean came to the President to talk about the cancer that was growing in the White House, that the President again recalled exactly what he was being told on his dictaphone. And the President knew that people in the White House had started this conspiracy rolling. Of course, at that time it was merely to gather political intelligence. The President had read some of the political intelligence because CRP would give it to Magruder. Magruder would give it to Strawn. Strawn would give it to Haldeman. And Haldeman has discussed it with the President, and we have that on tape. Now, just where do you get political intelligence from your opponent? The record is very clear because the President responds. Are they bugging Muskie? Are they bugging McGovern? And the inference which I draw, or is it just the DNC? Now, I don't know how the President would suspect they get this information, because you're only a burglar if you get caught. And so when the President asked information of the Attorney General, and he wanted and directed Ehrlichman to tell Kleindese that no White House personnel had prior knowledge of the break-in, it was strange how one member said yesterday, well, they didn't have prior knowledge. In other words, I will accept what the member said. I don't really believe that Liddy and Hunt called the President of the United States and said we got a hit on June the 17th. I do believe, however, that Ehrlichman knew, that Haldeman knew, that Mitchell knew that they had gotten enough money together for Liddy and Hunt. Liddy was transferred off the White House payroll to go work for Creep. Hunt still had his office in the White House. And Mr. Kleindese, who's supposed to be receiving this report for the first time, saw the head of the burglary on the golf course, and he never told the FBI. So the scenario, which one member said, it's true they never had prior knowledge. The only prior knowledge that people in the White House didn't know was when they were going to hit. But they certainly knew when they got information, whether they were in San Clemente, whether they were in Washington, D.C., or whether or not they were in Key Biscayne, that Liddy and Hunt were the people. As a matter of fact, the President says on one of the tapes that we received that he immediately suspected Colson. Let's find out what the plan is. Most of you heard that it was suggested to Mr. Mitchell. He was the new plan, as Martha clearly pointed out, that they felt if they could deliver Mr. Mitchell, then perhaps it would keep it away from the White House and keep it away from the presidency. I don't know why people insist that you read the whole paragraph after you talk about the Stonewall and plead the Fifth Amendment, because the president is saying he'd rather do it another way if it's going to come out at all. But the president concludes to read the bottom line, that whether you Stonewall, cover up, and save the plan, the last thing that he said to Mr. Mitchell is that, you know, up to this point, the whole theory has been containment. And you know that, John. But they're shifting now, and the important thing is to protect the people. The important thing is to go to the grand jury, get the information, and report back to those people who are the suspects by Henry Peterson.
The gentleman has consumed 5 minutes. I'll recognize the gentleman from Iowa, Mr. Maine, for 5 minutes.
Thank you, Mr. Chairman. Much has been made here of the conversations between the President and Mr. Henry Peterson, who was the Assistant Attorney General of the United States, on the evening of April 16th. I think that conversation has to be taken in its proper context, and it is important in considering this to recall the extensive examination of Mr. Peterson when he appeared in person before this committee. Now, he is one of the relatively few live witnesses which we had. Unfortunately, that was at a closed hearing. The press and the American people were not privy to that at the time. I wish very much that his testimony could have been seen as well as later read. But he testified that it was his understanding that under the circumstances it was entirely proper for him to give this information to the President. He testified that, in his opinion, it was not grand jury information, not information that had already been testified to before the grand jury, but had been otherwise developed by the government. And he said that certainly such information could properly be used by the President in his capacity as Chief of State, and that he fully expected the President to do so. He testified further that even if it were grand jury testimony, that it was his opinion as the Assistant Attorney General in charge of the Criminal Division that there would be no impropriety in the President divulging that to subordinates in the course of his official duties. And specifically, he said that he would be better able to determine whether or not Haldeman and Ehrlichman, to be specific, should be permitted to continue in their very important duties if he could discuss, he, the President, could discuss this information with them and determine whether he should keep them on or not. Now, it seems to me that Henry Peterson is certainly one person who has come unscathed through this ordeal as a very dedicated public servant, a professional of the very highest standards, and that his testimony should be given a great deal of weight. He further testified that it is generally the practice within the government for persons accused of wrongdoing to be confronted not only with the charges against them, but also the information on which those charges are based. And for that reason, he felt that it was entirely appropriate for the President to transmit that information to Herlichman or Haldeman. I think this testimony of his is so important that I want to refer to it in detail, and this is during the examination by Mr. Dennis of Indiana at page 142 of Book 3. Question. Mr. Peterson, I think you testified earlier that the information which you transmitted to the President of the United States was not, in fact, grand jury testimony, but rather material and evidence which you and the Department of Justice had accumulated and acquired by your own investigations. Is that correct? Answer. That is right, but it is a treacherous area. At the time I was receiving information, it was not grand jury information, but that same information, maybe within a matter of a day, would become grand jury information. Question. I understand that. However, at the time you had it and at the time you transmitted it, it had not yet become so. Is that true? Answer. Well, certainly at the time I transmitted it. Whether at the time, certainly at the time I got it. Whether or not it was at the time of transmittal it was grand jury information, I was not keeping that close track of it. Mr. Dennis. Okay. And you testified, however...
Consume 5 minutes.
Would the chairman yield to me 2 additional minutes?
That will come out of the 10 minutes
yes,
that is allotted to the gentleman is recognized for 2 more minutes.
Thank you, Mr. Chairman. And you testified, however, that had it in fact been technically grand jury testimony, that in your legal opinion you had a perfect right to transmit it to the President. Is that right? Answer, yes, sir. And I think you testified also that had it in fact been technically grand jury testimony, that in your legal opinion it would be entirely proper, correct, and legal for the President in the discharge of his administrative function in determining whether or not to fire Haldeman and Ehrlichman, what he should do about them and so on, to inform them of the charges against them. Is that correct? Answer by Mr. Peterson, yes, sir. Now, similar answers were given by this distinguished public servant to a number of congressmen who questioned him on the subject, and it seems clear that much ado is being made about nothing in this particular paragraph insofar as it relates to the testimony that the President did transmit information received from Mr. Peterson. Thank you. I yield back my time to Mr. Dennis.
The gentleman from Indiana is recognized for the remainder of the time. 3 minutes.
Thank you, Mr. Chairman. Mr. Maine has made my speech for me and made it very well. I'm very happy that he recalled that colloquy that I had with Mr. Peterson and called it to our attention because it's the answer. Mr. Peterson said in the first place it wasn't grand jury testimony altogether. Some of it was, some of it wasn't. In the second place, if it had all been grand jury testimony, I'd have had a perfect right to tell the President of the United States about it, as I did. In the third place, the President of the United States had a perfect right to take up with these people the general subject matter with which they were charged for his administrative purposes and in order to determine whether or not they ought to be fired or retained, and I expected him to do that when I talked to him. And there wasn't anything illegal about it. Now, that's the Peterson testimony. Now you're going to hang anybody because of that transaction when that's what the man involved has to say about it. It's very, very difficult to see. Mr. Peterson has no complaint, and I wouldn't think this committee would have any complaint either. Now, that's adequately covered, and I hope everyone here understands exactly the procedure we're going through. Yesterday we gave these people a little hard time because they wouldn't file an ordinary charge, which, as Mr. Lattis said, would be granted to any jaywalker in the land. So today they concocted a scenario, and we have a series of motions which nobody intends to vote for, even including the charming gentleman who makes them, just so they can talk about specifics that they weren't willing to plead. That's all right. It's good, clean fun, I guess. A little bit farcical, I think, for such a serious procedure. I am afraid some of the bias is against the president is showing here and there in this kind of an operation. I'm afraid so. But really there isn't very much more to say about this particular charge, because the man who was involved and whose information was supposed to be transferred has no complaint and says it was perfectly all right. I think the gentleman from New Jersey, Mr. Salmon, wanted me to yield to him, and I'll be happy to do so.
Thank you. My only purpose in seeking this 1 minute, I have a question for my friend from Alabama. On my motion to strike, you voted no. On the second one, of course, we had no vote. On 3 and 4, you only voted present. 5 and 6, we had no vote. Now, 7, I'm curious. Are you going to vote for your own amendment, or are you going to continue to call on people to defeat your amendment?
The time in...
Mr. Chairman, may I answer the gentleman, Mr. Chairman?
Unanimous consent to have the gentleman answer.
The caliber of the debate is so outstanding, Mr. Sandman, that it leaves me undecided at the conclusion.
I recognize the... The committee will please be in order, and I think it's important that we try to maintain some decorum in this chamber. The gentleman from Illinois is recognized for 5 minutes.
Mr. Chairman, members of the committee, I've spoken to this issue before, and I regret the need to have to go back into it, but I guess this is what we've decided to do today. Let me just say that I think the American people, if they want to suitably apprise themselves of the facts surrounding the events of April 15th, ought to get a hold of the transcripts and look at them. The 2 preceding speakers forgot to relate a couple of important events. The President of the United States, who was interested in finding out about the involvement of Haldeman and Ehrlichman, his 2 top aides, had specifically assured Henry Peterson, the new top law enforcement officer investigating the Watergate situation, that he would not divulge any information given to him. And he said it something like this: "You're talking only to me, and there's not going to be anybody else in the White House staff." In other words, I'm acting consul and everything else. The president then suggested that the only exception might be Dick Moore. When Peterson expressed some reservation about information being disclosed to Moore, the president said, "Let's just better keep it with me then." At that meeting, Peterson supplied the president with a memorandum, which he had requested on April 15th, summarizing the existing evidence that implicated Haldeman, Ehrlichman, and Strawn. Later that same day, April 16th, there was a telephone conversation. Even more specific, the president told Mr. Peterson this. He asked Peterson if there were any developments he should know about, and he reassured Peterson that, of course, as you know, anything you tell me, as I think I told you earlier, will not be passed on, because I know the rules of the grand jury. Now, it is true that some of the information that was given to the president by Henry Peterson was not strictly grand jury information, although, as the gentleman, my friend that spoke before me, said that it was in a treacherous area. Let me just say that what the president did is extremely significant, because in examining Henry Peterson myself, and this has not come out, Henry Peterson said, in his opinion, there wouldn't be anything wrong with relating the charges to the 2 top aides so that they would be apprised and he could get somebody else to take their place. I specifically asked if he differentiated between the charges and telling them to take some positive course of action. Henry Peterson said, "Do you mean tactics?" And here was the conversation. Now, in the light of this I'm examining Henry Peterson. You testified earlier this morning, I think, and frankly, I agree with you, that what you said, that it is not improper for you, I don't think it's improper for you to divulge this to the President. What concerns me so much about this is that the President didn't seem to be revealing charges. He is stating specific information and possibly even making suggestions to them, what they could do. Now, I'm referring specifically to what the President told to two potential criminal defendants on the morning of the 17th. The President told Haldeman that the money issue was critical. Quote, "Another thing, if you could get John and yourself to sit down and do some hard thinking about what kind of strategy you are going to have with the money. You know what I mean?" My recollection is Haldeman said, yeah. And then he goes on and he takes up, after some material deleted, he goes into the callback. What does callback know? What is callback going to say? In addition, the President instructed Haldeman, well, be sure that Calmback is at least aware of this, that LaRue has talked very freely. He is a broken man. When Henry Peterson said that he didn't think there was anything wrong with advising of the charges, he wasn't talking about the President trying to get them to engage in some kind of tactics. Not only was that true, he differentiated between advising even of charges to the top aides and advising Calmback, who had already been implicated, and it was suggested to the President earlier that Calmback was going to have to be called as a witness. I suggest that when Henry Peterson said in response to a question by Mr. Eilberg, we were not talking about Federal Rule 6E that relates to the grand jury. We're talking about Section 1503 of Title of 18, which has to do with the impediment, the obstruction, the due administration of justice. And I suggest that it's up to each one of us members to look at the facts that have been related by by the President's own transcripts and make up their mind whether they think that the President was simply relating to Haldeman and Ehrlichman the charges that had been leveled against them, or whether he was telling them what they should do.
Would the gentleman yield briefly? Yeah. I think in evaluating that testimony, as you've so ably delineated it, recall a conversation on April 16, 1973 in the President's transcripts, GPO, page 941, Nixon. Well, let me say, Al, I've got Peterson on a short leash. Ehrlichman, okay. Thank the gentleman.
Well, that is true. Let me just say in closing, in fairness to my friend Mr. Wiggins, who has just slipped me a note, Henry Peterson further suggested, after this kind of an examination that dealt with the difference between charges and tactics, and somebody like Calmback, who was not a top aide, that he also told Haldeman to notify, he suggested that it's a question for this committee to determine whether there was corruption in the mind of the President. In other words, what were the President's motives? That's the issue.
Time of the gentleman has expired. All time has expired, and the question is now on the motion of the gentleman from Alabama. All those in favor of the motion, please signify by saying aye. Aye. All those opposed? No. The noes have it.
Mr. Chairman,
have it.
On this I demand the ayes
The
and nays.
gentleman from New Jersey demands a roll call vote, and the clerk will call the roll. All those in favor of the motion, please signify by saying aye. All those opposed, no.
Mr. Donahue. Mr. Brooks. Mr. Kastenmeier.
No.
Mr. Edwards.
No.
Mr. Hungate.
No.
Mr. Conyers.
No.
Mr. Eilberg.
No.
Mr. Walde.
No.
Mr. Flowers.
Present.
Mr. Mann.
No.
Mr. Sarbanes.
No.
Mr. Seiberling.
No.
Mr. Danielson.
No.
Mr. Drinan.
No.
Mr. Rangel.
No.
Miss Jordan.
No.
Mr. Thornton.
No.
Miss Holtzman.
No.
Mr. Owens.
No.
Mr. Mezvinsky.
No.
Mr. Hutchinson.
Aye.
Mr. McClory.
No.
Mr. Smith.
Aye.
Mr. Sandman.
Aye.
Mr. Railsback.
No.
Mr. Wiggins.
Aye.
Mr. Dennis.
Aye.
Mr. Fish?
No.
Mr. Maine?
Aye.
Mr. Hogan?
No.
Mr. Butler?
No.
Mr. Cohen?
No.
Mr. Lott?
Aye.
Mr. Freilich?
Aye.
Mr. Moorhead?
Aye.
Mr. Mariziti?
Aye.
Mr. Latta?
Aye.
Mr. Rodino?
No.
Mr. Chairman, may I be recorded as no?
Mr. Brooks votes no.
And the clerk will report.
Mr. Chairman, 11 members have voted aye, 26 members have voted no, 1 member has voted present.
And the motion is not agreed to. Chair recognizes the gentleman from Alabama, Mr.
Thank you, Mr.
Flower.
Chairman. I have an amendment or a motion to offer to subparagraph 8.
Clerk will report the motion.
Amendment by Mr. Flowers. Strike subparagraph 8 of the Sarbanes substitute.
Mr. Chairman, I ask unanimous consent that the debate on this amendment be limited to 20 minutes, to be divided 10 minutes to the proponents of the motion and 10 minutes to the opponents.
Without objection, it is so ordered.
And I have discussed this matter with the gentleman from Utah, Mr. Owens, and I would like to ask if he has any comments to make on this subparagraph at this time.
The gentleman is recognized for 5 minutes.
I'll say to the gentleman from Alabama that it so happens that I am prepared to comment on subparagraph 8 and express my appreciation to him for yielding. Subparagraph 8 deals with the question of whether the President made false or misleading public statements for the purpose of deceiving the people of the United States into believing that a thorough and complete investigation had been conducted with respect to allegations of misconduct on the part of personnel of the executive branch of the United States and personnel of the Committee for the Re-election of the President. And there's been a great deal said during the course of this debate on this subject. I will try to find some new materials and make reference to them. During the course of preparation for this final debate, I think the most significant, the most interesting document that I went over was a compilation by the committee of presidential statements on the Watergate break-in and its investigation. And I went through with a red pen one night, spent 3 or 4 hours on it, and underlined all of the statements of the President during this period of time, which I found to be, as I assessed the evidence, either false or misleading. And to go through this, or less than a straightforward, candid statement. And I find that there are red marks on almost every page. And it was a very telling point for me. I would like to refer...
The gentleman will refer until the committee and the gentlemen and ladies in the audience in order, and gentlemen will proceed.
Thank you, Mr. Chairman. On October 5th, 1973, the President held a press conference. This was, I think, 2 weeks almost to the date of the time that Mr. Cox was fired on a Saturday night, the so-called Saturday Night Massacre, and the following Tuesday, as members will remember, there were a total of 94 members of the House who joined in impeachment resolutions, and following which the President gave up the tapes. But at the time of October 5th, the President, at least there were no tapes that were available. The President has asked this question. Mr. President, to follow up on the tapes question, earlier you have told us that your reasons are based on principles, separation of powers, executive privilege, things of this sort. Can you assure us that the tapes do not reflect unfavorably on your Watergate position, that there is nothing in the tapes that would reflect unfavorably? And the President, in front of the American people, says this: there is nothing whatsoever. As a matter of fact, the only time I listened to the tapes, to certain tapes, and I didn't listen to all of them, of course, was on June 4th. There is nothing whatever in the tapes that is inconsistent with the statement that I made on May 22nd or of the statement I made to you, ladies and gentlemen, in answer to several questions, rather searching questions, I may say, and very polite questions, 2 weeks ago, for the most part, and finally, nothing that differs whatever from the statement that I made on the 15th of August. I won't try to go into what those tapes have revealed, except to say that I think the committee, most committee members have commented at one time or another that it is the tapes which have presented the case, the real case, hard case of evidence against the President. Now I'd like to refer back which tapes were released within about a month of that time. Now I'd like to refer back to a presidential news conference of August 22nd in 1973. Again, this is several months before the tapes were released, at a time that the President indicated he would not release any tapes. In this press conference, the President made several assertions which I think were less than candid in his statements to the press and through them to the American people. He said that in the summer of 1972, Mr. McGregor, who had replaced Mr. Mitchell as director of his campaign, Mr. McGregor conducted a thorough investigation in 1972 about the involvement of White House personnel. Mr. McGregor has testified before the grand jury, sworn testimony before this committee in evidence, that he received no instructions from the President and that he did not conduct a thorough investigation about the involvement of White House personnel. In response to another question in that same press conference, the President said that on March 22nd, he had told Ehrlichman, Haldeman, and Mitchell and Dean that, quote, "We must get this story out. We must get the truth out, whatever and whoever it is going to hurt." When the tape finally was released and it became public, that conversation of March 21st, to which the President refers, was made public. And we have a recording, and the committee members have heard that recording, and they have heard the President instruct Mr. Dean and Mr. Mitchell and Mr. Haldeman and Mr. Ehrlichman this: "I don't give an expletive deleted. What happens? I want you all to stonewall it. Let them plead the Fifth Amendment, cover up or anything else. If it'll save it, save the plan. That's the whole point." And then later on he says, "I don't know, but that's, up to this point, the whole theory has been containment, as you know, John. Not only is there no such quote as the President quoted himself as giving, but when one reads the transcript, there is an exact direction to those four gentlemen to do the exact opposite thing."
Time of the gentleman has expired.
Thank you, Mr.
I recognize the gentleman from California, Mr. Moorhead, for 5 minutes in support of the amendment.
I think one thing, and that is that the people of this committee should realize exactly what is going on here this afternoon, and that is that although the staff and the members of the majority have refused to give us a detailed complaint to be filed against the President of the United States so that he could tell exactly what he is charged with, the other side has gone into an attempt to present a lot of evidence, or a lot of facts that they claim as evidence to this committee that really is not supported by the materials that we have taken in their best context. I know Mr. Flowers is doing the thing that he feels is important for him to do in bringing up each one of these motions to strike, but he obviously is against them or he would vote for them. And then each one of the members of the majority, those wanting to have impeachment, is reading a copy of a paper prepared, I suppose, by our $1 million staff. The words sound so very close to being alike and in the same kind of a version that obviously they've been prepared by someone with a tremendous imagination. And I think that, of course, they have a right to express their opinion, but I do think that when we're considering such an important thing as the impeachment of a president, we ought to stick to the evidence that we have and the very best interpretation of the evidence that we have. Some of the things that have been stated are just not borne out by the facts. I just received a copy of the recent version that was just given, It was stated first that on June 22, 1972, the President publicly adopted as his position and as a factually accurate to the previous statements of Mitchell and Ziegler that the White House had no involvement whatsoever in the Watergate break-in and that the CRP had no legal, moral, or ethical accountability for the break-in. There's absolutely no evidence that the President had any knowledge of the involvement of White House people at the time that he made this statement. In fact, the evidence is to the contrary. He had been told that there was no involvement. It was also stated as the grounds for this section that on August 20, 1972, the President publicly stated that at the President's direction, Dean had conducted a complete investigation which indicated that no one in the White House staff or in the administration was involved in the Watergate, and that the CRP was also conducting an investigation at the Watergate. Ehrlichman directed Dean to conduct an investigation to see if anyone in the White House was involved. No one presently employed in the White House was involved, as was stated. It's true there had been one man in the White House that had been there previously that had left. The third statement was given that on October 5, 1972, the President publicly stated that he wanted every lead carried out by the FBI to the end because I wanted to be sure that no member of the White House staff and no man or woman in a position of major responsibility in the Committee for Re-election had anything to do with this kind of a reprehensible activity. The statement was true. The President did tell Mr. Gray to pursue his investigation. This goes down the line, and I don't intend to go through all of these various sections, but I want one thing very clear, and that is from the presentations of the live witnesses before this committee, it's apparent that Mr. Dean was the man in the White House that had the responsibility to look into the Watergate investigation. And Mr. Colson told us here, with no axe to grind, that everything was forwarded to Dean that pertained to Watergate. Dean was the man that they looked to for any investigation that was done. And when we listen to the tapes of a conversation between the President and Mr. Dean prior to Mr. Dean going up to Camp David, the President's comment, and I don't remember the exact words, well, this will give you an opportunity to think about the things that have happened and to prepare a report. Mr. Dean went up to Camp David, did not prepare a report, although he was again specifically ordered to do so while he was there. I guess his involvement was too deep for him to really be able to prepare something. And as a result, Mr. Dean came back without the report for the President. But it is perfectly clear that the President looked to Dean for the investigation, for information on this matter, and
time of the gentleman from California has expired. The gentleman from Indiana.
Thank you, Mr. Chairman. I don't just happen to have a lot of prepared material by me like as my friend from Utah does, because to use one of the President's favorite words, the scenario hasn't been so well written over here as it has been over there, where this has been very carefully taken care of by the assistance of staff counsel, and everyone has his piece. But I think I can still read English, even unassisted. And I don't need a lot of reference, I don't believe, to help convince any reasonably open-minded person, if there is such a person on the committee, that this particular paragraph belongs out of here on a motion to strike, honest to God, just on ordinary garden variety principles, without much reference to the weighty matters we're dealing with, because it just doesn't have anything to do with what we're talking about. We should go back to the beginning of Article 1 and see what we're discussing. The article starts out and it says that on June 17th of 72, agents of the committee to re-elect committed an illegal entry into the Democratic National Committee headquarters, and subsequently thereto, Mr. Nixon, pursuant to plan and so forth, acting through various subordinates, did various things to delay, impede, and obstruct the investigation of such illegal entry. That's what this is all about, and to cover up and protect those responsible. Now, that's the gravamen of the charge. He tried to obstruct the investigation of an illegal entry and protect those responsible. Then they begin to spell out how that was done, not how something else was done. And you come down to this number 8, and it says, making false or misleading public statements. Now, I don't care whether they're false or misleading or not for present purposes. The question is, do they obstruct the investigation of this break-in and protect the people who did it? And it says here, not for that purpose, because I suppose anyone could see that that wouldn't do very much for obstructing investigation of the break-in, but for the purpose of deceiving the people of the United States into believing that a thorough and complete investigation had been conducted, when I suppose, in fact, it hadn't been. Now, if that is any kind of a charge at all, I certainly submit it isn't the charge of Article 1. You could have just as false a statement, and I'd like to make clear that I'm not conceding there was any false statement, but for the sake of the argument, you could have one. And you could have one made for the purpose of making people think that there had been an investigation of this break-in, and you still would not have any single thing which implemented the charge here, which is obstructing the investigation of the break-in. What difference does it make what the old lady in Dubuque thinks about whether there's an investigation or not? The question is, was there? And was something done which interfered with the investigation? The President of the United States could put anything he wanted to in all the papers in the country, and it wouldn't interfere with that investigation, which is what we're talking about here. This number 8, whatever it is, just doesn't belong here as a specification such as it is of this particular charge. And I think my good friend from Alabama, whom I greatly love, respect, and admire, will vote with me to strike this one, because I just simply suggest and submit that there isn't any logical ground on which you can leave this monstrosity here in this particular place. I just don't see it. I yield to the gentleman from Mississippi.
I think, gentlemen, the yielding this particular charge, I think there are 3 things we should keep in mind. First, a question. Did the President have knowledge that he was allegedly making false statements? Secondly, some of the arguments advocated in behalf of this section are actually true. And so what? And thirdly, are we now in the business of impeaching presidents for making misleading statements?
The time of the gentleman from Indiana has expired. I now recognize the gentleman from California, Mr. Walde, for 5 minutes in opposition to the amendment.
I think the charge that the cover-up was really continuing at the very highest level is embodied in this declaration that the President was making the false or misleading public statements for the purpose of cementing the cover-up. All the activities of those below the President became manifested in terms of their certainty when the President himself says that this matter is now being investigated thoroughly and that the results we will give to you are the only results that need be given. Now, there may be some question as to whether the President had within his knowledge facts up through and until April 30th, 1973, because all of those statements were made at a time when we did not have in our possession the edited transcripts. The President then, on April 30th, May 22nd, August 15th and August 22nd continued to make statements that were less than complete. Now the question is, was the cover-up continuing on April 30th and dates subsequent thereto? It's my own contention that the cover-up was continuing in those public statements because there's no question that the erroneous statements, factually, from April 30, May 22nd, August 15, and August 22nd, were clearly known to the contrary to the President because he had edited transcripts of all his conversations. He had full transcripts of all his conversations. The last public statement the President made on this issue to the nation was April 30th of this year. April 30th of this year, 1974. And he said, as he has said in every one of these statements to the people of this nation, tonight I am giving you the definitive story, the real story of Watergate. Everything you need to know about Watergate is contained, and he pointed, as Mr. Latta did last night, to his 47 volumes of edited transcripts. And he said, up to this point, you haven't had the full story, though he had made about 10 public statements saying we had had the full story, but this is the definitive full story, the edited transcripts which he is releasing to the nation. And he said, after you've read these, you need no more information. It is all there. Now we ought to examine, was he telling the truth to the public on April 30th of this year, when he said all the truth of Watergate is contained in these edited transcripts. The nation relied on it, as the President thought they would, and believed this is the final statement about Watergate. Everything up to this point has been less than full because the President says now it's a full story, though it goes back to April 30th, 1973. The President says in April 1974, what I've told you before April 30th, 1973 was not the definitive story, but this is. Everything now is in these transcripts. Well, everybody heaved a sigh of relief and said, well, thank God, the President finally has told us the full story of Watergate, and that is about time. And we're pleased and we're relieved that the President has now told everything there is to know about Watergate. The committee began examining the edited transcripts, and the committee got a hold of tapes from which those transcripts had been transcribed. And the tapes on our equipment, compared to the President's edited transcripts, were incredibly more incriminating, and in fact produced a great deal more of the story of Watergate. So that the last public statement of the President, April 30, 1974, that this is the full story of Watergate, again has been false and misleading in the extreme, because it was misleading in every aspect in those mistaken transcripts, those altered transcripts, misleading in a manner beneficial to the President, intentionally omitted and deleted, intentionally deceptive and misleading. The allegation making false or misleading public statements for the purpose of deceiving the people of the United States is an allegation that has been sustained amply as recently as April 30th of this very year. I yield back the balance of my time.
The time of the gentleman from California has expired. All time has expired, and the question now occurs on the motion of the gentleman from Alabama. All those in favor of the motion, please say aye. Aye. All those opposed? No. The noes appear to have it. The gentleman from New Jersey? Call of the roll is demanded, and the clerk will call the roll. All those in favor of the motion, please signify by saying aye. All those opposed, no.
Mr. Donahue? No. Mr. Brooks? No. Mr. Kastenmeier? No. Mr. Edwards? No. Mr. Hungate?
No.
Mr. Conyers?
No.
Mr. Albert.
Sustained amply as recently as April 30th of this very year. I yield back the balance of my time.
The time of the gentleman from California has expired. All time has expired, and the question now occurs on the motion of the gentleman from Alabama. All those in favor of the motion, please say aye. Aye. All those opposed? No. The noes appear to have it. The gentleman from New Jersey?
The nays.
Call of the roll is demanded, and the clerk will call the roll. All those in favor of the motion, please signify by saying aye. All those opposed, no.
Mr. Donahue?
No.
Mr. Brooks?
No.
Mr. Kastenmeyer? Mr. Edwards?
No.
Mr. Hungate?
No.
Mr. Conyers?
No.
Mr. Eilberg?
No.
Mr. Walde?
No.
Mr. Flowers?
Present.
Mr. Mann?
No.
Mr. Sarbanes?
No.
Mr. Seiberling?
No.
Mr. Danielson?
No.
Mr. Drinan?
No.
Mr. Rangel? No. Miss Jordan?
No.
Mr. Thornton?
No.
Miss Holtzman? No. Mr. Owens? No. Mr. Mezvinsky? No. Mr. Hutchinson?
Aye.
Mr. McClory?
Aye.
Mr. Smith?
Aye.
Mr. Sandman?
Aye.
Mr. Railsback?
No.
Mr. Wiggins?
Aye.
Mr. Dennis?
Aye.
Mr. Fish?
No.
Mr. Maine?
Aye.
Mr. Hogan?
No.
Mr. Butler?
No.
Mr. Cohen?
No.
Mr. Lott?
Aye.
Mr. Freilich?
Aye.
Mr. Moorhead?
Aye.
Mr. Mariziti?
Aye.
Mr. Latta?
Aye.
Mr. Rodino?
No.
Mr. Chairman,
Clerk will report.
12 members have voted aye, 25 members have voted no, 1 member has voted present.
And the motion is not agreed to. I recognize the gentleman from Alabama, Mr. Flowers. And the clerk will report the motion.
Amendment by Mr. Flowers. Strike subparagraph 9 of the Sarbanes substitute.
Mr. Chairman, I ask unanimous consent that the debate on my amendment be limited to 20 minutes, with 10 minutes being allocated to the proponents of the amendment and 10 minutes to the opponents.
Without objection, it is so ordered.
And I'll yield my 5 minutes to the gentleman from Missouri, Mr. Hungate.
I thank the gentleman for yielding. Mr. Chairman, we've had complaints concerning the lack of direct evidence and complaints concerning circumstantial evidence. And I want you to know there's people in jail today on circumstantial evidence. Ordinary citizens, their lawyers, and the courts throughout the land act on circumstantial evidence every day. The President had and has agents, confidants, and employees. In this debate, we have been shown the problems of agency and respondeat superior. I sometimes think that we might be convinced that the head of General Motors doesn't make motor cars. But yes, Virginia, there is a law of agency, and it applies to the President as it does to you. Now, direct from the President's own transcripts and in his own words. This is at 8:55 a.m. This conversation began on April 14, 1973, in the Executive Office building. President Haldeman and Ehrlichman, the President speaks. Lovely wife and all the rest, it just breaks your heart. And say this is a very painful message for me to bring. I've been asked to give you, but I must do it, and it is that. Put it right out that way. Also, I would first put that in so that he knows I have personal affection. That's the way the so-called clemency has got to be handled. Do you see, John? Ehrlichman replies, I understand. Later in the same day, in a conversation taking place at beginning at 11:22 p.m., the President says, one point, you are going to talk to Dean? Ehrlichman, I am. President, what are you going to say to him? Ehrlichman, I'm going to try to get him around a bit. It's going to be delicate. President, get him around in what way? Ehrlichman, well, to get off this passing the buck business. President, John, that's Ehrlichman. It is a little touchy, and I don't know how far I can go. President, John, that is not going to help you. Look, he has to look down the road to one point that there is only one man who could restore him to the ability to practice law in case things go wrong. He's got to have that in the back of his mind. Ehrlichman, Later in the same conversation, in response, the President says, well, with Dean, I think you can talk to him in confidence about a thing like that, don't you? He isn't going to. Ehrlichman, I'm not sure. I just don't know how much to lean on that reed at the moment. President, I see. Ehrlichman, but I will sound it out. President, well, you start with the proposition. Dean, the President thinks you have carried a tremendous load, and his affection and loyalty to you is just undiminished. Ehrlichman, all right. President, and now let's see where the hell we go. Ehrlichman, President, we can't get the President involved in this. His people, that's one thing. We don't want to cover up, but there are ways. And then he's got to say, for example, you start with him certainly on the business of obstruction of justice. Ehrlichman, that's right. President, look, John, we need a plan here. And so that LaRue and Mardian and the others, Ehrlichman, well, I am not sure I can go that far with him. President, no, he can make the plan up. Ehrlichman, I will sound it out. Now, page 115 of the transcripts of 8 recorded presidential conversations on the date of March 21st, 1973. The President says, well, another way to do it then, Bob. Mr. Haldeman is there.
and John realizes this, is to continue to try to cut our losses. Now, we have to look at that course of action. First, it's going to require approximately $1 million to take care of the jackasses that are in jail. That could be arranged. Haldeman or Dean, got an option there. Yeah. President, that could be arranged. But you realize that after we are gone, I mean assuming these unintelligible are gone, they're going to crack. You know what I mean? And that'll be an unseemly story. Eventually all the people aren't going to care that much. Dean, that's right, it's President. People aren't going to care. Dean, so much history will pass between then and now. President, in other words, what we're talking about is no question.
Gentleman has consumed 5 minutes. The gentleman from New Jersey, Mr. Sandman, is recognized for 5 minutes in support of the amendment.
Yield to me for 1 minute.
Yield to the gentleman from Illinois.
I hope that this part of Article 1 will be stricken. I think that this, above anything else perhaps, demonstrates the contradictory evidence which is presented here, and with the supposition that somehow this is clear and convincing proof. The President, in this conversation to which Mr. Hungate referred, used the expression best wishes and gratitude, and that's going to be inferred and interpreted as clemency. I think the only true subject of clemency was the one with Colson following Mrs. Hunt's death, which is perfectly understandable when Hunt's wife had been killed and he was suffering from that loss and that about to go to jail. The subject of clemency would be discussed with Mr. Colson and in that context. And it seems to me to stretch that into an article of impeachment against the President is completely unsupported whatever. Thank the gentleman for you.
I thank you very much. It looks like that I can't yield in the limited time that I have because I would like to make a summary of what I've witnessed here, and I know the people have too. Isn't it amazing how that magic vote has held so firmly? Even to a point where the gentleman who moved all of these motions of strike didn't even support his own motion. Can you imagine such discipline? Uncanny, to say the least. And this is why I suggested when we opened our session today that this would be such a fruitless waste of time, and it has been. 220 million people know what you were up to. You didn't kid anybody. You tried to sell them a bill of goods. And we didn't, with all of our arguments, persuade a single vote. There's no way humanly possible to do that at this forum. And this is why I suggested to my colleagues, there will be another day, and God bless us that we have the right to have another day, and that's going to be on the House floor. Now, let's just take a look at where we are today. Certainly some good soul who makes up his mind, as we've heard so many say, the way his conscience would make him believe, would give us a vote on this one. Because if ever one of these things should be stricken as number 9, such hypocrisy in this charge. This says that the President is, I cannot yield in my limited time. The President has tried to give favored treatment to some people to keep their silence, make false rewarding testimony, and maybe when I'm finished, please, let me try to get some votes on this when I'm reaching out for souls.
You persuaded me already, and if you may talk me back out of it. I'm going to vote with you on this one.
It sounds like I'm reaching you, so I'm going to give you. I'll give you my last 30 seconds if you let me get underway. Now, all of the people who were involved in this thing, point out one of them that got favored treatment. One. So much has been talked about. They make the most out of every word that this man ever breathed. The throwing of that ashtray. Why, if I had a guy like John Dean working for me, I'd probably throw him out of the house, not throw an ashtray. And so would you. At any rate, here is a man with all the troubles of the world on his head, and every little thing that he says is multiplied up to the rooftop. They didn't even give him any credit for ending a war or anything like that. In fact, they got a little peeved that Henry Kissinger was doing so well, and they thought that he ought to come back and testify about something he said or he didn't say in the Senate. Nobody here is interested, apparently, in the country. We're interested here, I suppose, in getting somebody. Now, the most important statement of all affecting clemency and is right in the Senate Select Committee testimony, John Ehrlichman, who did a lot of things wrong. Nobody said he didn't. But we're talking about testimony. What did Ehrlichman say when he walked with the president on the beach at San Clemente? He talked about clemency, and the president said this is something that cannot be done and will not be done. That, I think, disposes of that argument. Now there's 37 fair-minded people here that are going to vote their conscience, and for God's sakes, do it on this one, because you haven't done it on the other 8. Now, what earthly good has been accomplished by all of this?
The gentleman has consumed 5 minutes.
I'd like to have unanimous consent to yield 30 seconds to my friend from Alabama. I think he's going to vote for this one.
This is over and beyond the 20 minutes, but without objection, it is. Oh, the gentleman has
Mr. Chairman,
5 more minutes in support of the amendment.
The gentleman from New Jersey persuaded me. I was already persuaded, I might add, on this particular sub-paragraph.
The gentleman from New Jersey, Mr. Mariziti, is recognized.
Thank you, Mr. Chairman. I support the motion of the gentleman from Alabama for a number of reasons. First, let me say that there are not sufficient allegations for this committee to know exactly what the charge is. There are not sufficient allegations for the respondent, the President of the United States, to know what the specific charge is. A simple reading of the paragraph will indicate exactly what I mean. Endeavoring to cause prospective defendants. What prospective defendants? If we know who they are, and we certainly ought to know who they are if they exist after 7 months of investigation, why could not the staff or the proponent of the resolution, the article of impeachment here, have named them? Goes on to say, and individuals duly tried and convicted and so on, to expect favored treatment and consideration. What favored treatment and consideration? In return for their silence or false testimony, or rewarding individuals. What individuals and what reward? I can only assume, from what I've heard, that we're speaking here of possibly executive clemency. I only know that from what I've heard presented here, not by an amendment to the articles of impeachment, which I certainly would be satisfied with, but with a recitation of evidence or information that I suppose in due course is expected to be set forth to prove the allegation. And this is a problem we've had here for 2 days. And I'm sure that, as I said previously, as lawyers, we know exactly what we're talking about here and what the difference is between allegations set forth in the article of impeachment and the evidence and the proof. I will in just a moment. I don't know if I'll have enough time, and I'd like to finish my presentation. And let me say that that's what we should be doing, amending the articles of impeachment. But let us go to the facts that have been discussed, and I think that since they have been discussed, it's only proper that we who may not agree should have an opportunity to answer.
Yes, it's true that the President has, on a number of occasions, discussed this subject as other subjects have been discussed, and we know how he has carried on his activities as has been evidenced by the testimony here and the other information we have. He meets with his staff and he throws out ideas and suggestions, and he wants alternatives, considers alternatives, and then suddenly makes up his mind and says yes or says no. And I think it's very clear that he has rejected, and he rejected clemency on a number of occasions. I think all we've got to do, just as soon as I conclude, all we've got to do is refer to the tape of March 21st, 1973, and after discussing clemency, he says very emphatically, no, it is wrong, that's for sure. No, it is wrong, that's for sure. And then again, in the same tape, and the second thing is, we are not going to be able to deliver on any of a clemency thing. So what I submit to you, members of the committee, is that certainly members of his staff had made many suggestions to the President. They talked to him. He listens to them. And then he accepts or rejects. In this case, in my opinion, he very affirmatively rejected clemency. And
time of the gentleman from New Jersey has expired. The gentleman from Maryland, the gentleman from Missouri is recognized for 5 more minutes to conclude debate.
Thank you, Mr. Chairman. I yield 2 minutes to the gentleman from Maryland, Mr. Hogan.
I thank the gentleman from Missouri for yielding, and I'd like to briefly address the questions asked by Mr. Mariziti with respect to the last sentence in this paragraph about rewards to individuals who had perjured themselves. Mr. Mariziti said, what individuals and what rewards? And I asked my friend from New Jersey, and he is my friend, what the reasonable and prudent man would conclude from the facts which I'm going to recite. Jeb Magruder testified that he had, in January 1973, told H.R. Haldeman that he would commit perjury in the trial of the United States versus Liddy, which he did. On February 19, 1973, Dean testified that he prepared a talking paper. He testified that on that date, he prepared a talking paper for a meeting between Haldeman and the President, at which Haldeman would discuss with the President an administration job for Magruder. The paper said that Magruder would be vulnerable if nominated for a position which required Senate confirmation, because Sloan was going to testify against him and reveal a number of things. Now, we tried to subpoena the tape of that conversation between Haldeman and the President. It was refused. But we do know that after that meeting between Haldeman and the President, Magruder was offered the highest-paying job available in the government, which didn't require Senate confirmation. He got a $36,000 job at the Department of Commerce, and he retained that position for even a month after Dean had discussed with the President on March 21, 1973, that Magruder had committed perjury. I submit an individual who was known to have committed perjury was rewarded for the perjury. Well, it's not my time. The gentleman from Missouri has the time.
If 2 minutes of the gentleman have expired, and the gentleman from Missouri has 3 minutes remaining.
I thank the gentleman from Utah. I yield briefly to the gentleman from Utah.
I had a point of clarification.
Mr. Hungate?
I had a prior request, Mr. Mersey. I'm sorry, Mr. Owens.
That the gentleman read first is going to require approximately $1 million to take care of the jackasses that are in jail. That could be arranged. Is that the same group in jail that we were assured by the President's counsel the President justified payment of $500,000 for as on a basis of compassion and concern?
Mr. Owens, that may be, but in Missouri the term jackass is not necessarily derogatory. Mr. Mariziti.
Thank the gentleman.
Let me know when I got 2 minutes. How much time I got?
Thank you very much, Mr. Hungate. Appreciate your yielding. Now, in reference to the question propounded by my friend from Maryland, if he has the information, and apparently has some of it, I'd like to ask the gentleman why he has not listed these names. That is what we are talking about in the articles of impeachment, the names and the favored treatment and so on. We want the specifics. I'm not talking about the evidence. The specifics and the allegations. Now, in reference to the charge that you made, there's no evidence that the President has offered the job to Magruder. Alderman denies that Magruder said he perjured himself. It's his word against Magruder's. There's no evidence the President offered the job to Magruder. Thank you.
I thank the gentleman, and it seems we end as we began with a question. And there are different views here, and I widely respect them, and I think all of those here respect the different views because I think they help the country to develop the truth. Some wise man has written that the truth is seldom pure and never simple. And I think we see that here today. I would apologize to some if they found occasional attempts at humor offensive, but I've never thought a sense of humor need to destroy your sense of responsibility. And in my case, I felt it better to have a sense of humor than no sense at all. But to close on a most serious note, because this is a solemn responsibility that weighs heavily upon all of us and upon the staff and the American people. We all seek to do the right and proper thing, and I hope we can have divine guidance in the difficult decisions we must yet make. And remember that I can see Omaha Beach, the National Cemetery there, to the dead of World War II of the United States, and in stone above that monument to those men it says, "They endured all and suffered all, that mankind might know freedom and inherit justice." And I hope our deliberations here will promote that cause. Thank you.
The time of the gentleman from Missouri has expired. All time has expired, and the question now occurs on the motion of the gentleman from Alabama. All those in favor of the motion, please say aye. Aye. All those opposed? No. The noes appear to have it. The gentleman from New Jersey.
On that, I demand the yeas and nays.
Gentleman from New Jersey demands the yeas and nays, and the call of the roll is ordered. The clerk call the roll. All those in favor of the motion, please signify saying aye. All those opposed, no.
Mr. Donahue.
No.
Mr. Brooks.
No.
Mr. Kastenmeier.
No.
Mr. Edwards.
No.
Mr. Hungate.
No.
Mr. Conyers.
No.
Mr. Eilberg.
No.
Mr. Walde.
No.
Mr. Flowers.
Aye.
Mr. Mann.
No.
Mr. Sarbanes.
No.
Mr. Seiberling.
No.
Mr. Danielson.
No.
Mr. Drynan.
No.
Mr. Rangel.
No.
Miss Jordan.
No.
Mr. Thornton.
No.
Miss Holtzman.
No.
Mr. Owens.
No.
Mr. Mezvinsky.
No.
Mr. Hutchinson.
Aye.
Mr. McClory.
Aye.
Mr. Smith.
Aye.
Mr. Sandman.
Aye.
Mr. Railsback.
Aye.
That's a long time, Tom.
Mr. Wiggins.
Aye.
Mr. Dennis.
Aye.
Mr. Fish.
Aye.
Mr. Maine.
Aye.
Mr. Hogan.
No.
Mr. Butler.
No.
Mr. Cohen. Mr. Lott.
Aye.
Mr. Fraley.
Aye.
Mr. Moorhead.
Aye.
Mr. Mariziti?
Aye.
Mr. Latta?
Aye.
Mr. Rodino?
No.
Mr. Chairman,
Clerk will report.
15 members have voted aye. 23 members have voted no.
And the motion is now agreed to. Not agreed to. The question is, the gentleman from Texas, Mr. Brooks.
I move the previous question on the Sarbanes substitute as amended.
Chairman, I ask unanimous consent to proceed for 5 minutes.
Will the gentleman withhold the
I withhold and
motion?
withhold the motion until that time, yes.
Without objection to the so ordered.
Thank you, Mr. Chairman, and thank you, my colleagues on this committee. In approaching this grave matter, I said long ago that I would be guided by the facts and the Constitution and my own conscience. I honestly believe that I've been faithful to that commitment. I know for certain that I have nothing to gain, politically or otherwise, from what I must do here. But after weeks of searching through the facts and agonizing over the constitutional requirements, it's clear to me what I must do. And I emphasize that this is my own personal decision, what I must do. I don't presume to influence any other person, and I recognize that there can be differences on this grave matter. In this regard, Mr. Chairman, let me say just a few words. There are many people in my district who will disagree with my vote here. Some will say that it hurts them deeply for me to vote for impeachment. I can assure them that I probably have enough pain for them and me. I have close personal friends who strongly support President Nixon. To several of these close friends, who somehow I hope will hear and see these proceedings, I've said that the only way I could vote for impeachment would be on the realization, to me anyway, that they, my friends, would do the same thing if they were in my place on this unhappy day and confronted with all of the same facts that I have. And I have to believe that they would. I would not take the position that I do. Now, Mr. Chairman, I'm prepared to vote on this article of impeachment, but before so doing, I want to address my colleagues on this committee, and particularly my colleagues on this side of the aisle, my Democratic colleagues. Make no mistake, my friends, one of the effects of our action here will be to reduce the influence and power of the office of the President. To what extent will be determined only by future action in the House or in the Senate. We've heard some eloquent statements, and I honestly believe there's been more sincere thought and soul-searching put forward on this terrible proposition than on anything else that I've ever been connected with anyway. This is an extremely difficult vote for most of us. But let's face it, it's less difficult for some than others. Some have had to reflect on whether they could or would vote to impeach a president of their own party, a Democrat, if you will, if the facts justified it. I hope they never have that chance. I hope not one of us ever has to look into another matter of impeachment again. But I suggest to my friends here that they don't have to wait 107 years to vote on the next impeachment to prove responsibility. They will undoubtedly have many instances as time goes on to prove their capacity to meet those hard decisions that will have to come before this Congress or the next or the next. And I agree that Congress should exert itself. That's what we're doing here. But we will and should be judged by our willingness to share in the many hard choices that must be made for our nation, such as allocation of scarce resources, such as management of the forces of inflation and recession, such as balancing priorities and controlling the spending of the taxpayers' money. In the weeks and months ahead, I want my friends to know that I'll be around to remind them when some of these hard choices are up. And we'll be able to judge then how responsible we can be with our newly found congressional power. Thank you, Mr. Chairman. I yield to the gentleman from New York.
The gentleman yield me. I thank the gentleman for yielding, and Mr. Chairman for this opportunity to address not only the members on this side of the aisle who I've labored with for these last 7 months, but also my friends and supporters in New York who are also, by and large, supporters of the President's. Mr. Chairman, I intend to vote in favor of this, the first article of impeachment. This comes after long deliberation, but it comes because an analysis of the evidence in this proceeding has led me to this inescapable conclusion. I'm sure you realize that my vote is not cast lightly, that my decision has not been reached hastily, that is reached it all with deep reluctance only after I have been persuaded that the evidence for such a vote is clear, evidence warranting the recommendation by this committee of this article of impeachment to the House of Representatives. I thank the gentleman.
The
Regular order, Mr. Chairman. Regular order,
The question is before us, and there being no objection, I'm going to put the question, and the question occurs on the substitute offered by the gentleman from Maryland as amended. And all those in favor of the substitute of the gentleman from Maryland as amended, please signify by saying aye.
Aye.
All those opposed? No. The ayes appear to have it, and the call of the roll is demanded, and the clerk will call the roll. And all those who are in favor of the amendment of the gentleman from Maryland substitute as amended, please signify by saying aye, and all those opposed, no. Clerk will call the roll.
Mr. Donahue.
Aye.
Mr. Brooks.
Aye.
Mr. Kastenmeier.
Aye.
Mr. Edwards.
Aye.
Mr. Hungate.
Aye.
Mr. Conyers.
Aye.
Mr. Eilberg.
Aye.
Mr. Walde.
Aye.
Mr. Flowers.
Aye.
Mr. Mann.
Aye.
Mr. Sarbanes.
Aye.
Mr. Seiberling.
Aye.
Mr. Danielson.
Aye.
Mr. Drinan.
Aye.
Mr. Rangel.
Aye.
Miss Jordan.
Aye.
Mr. Thornton.
Aye.
Ms. Holtzman.
Aye.
Mr. Owens.
Aye.
Mr. Mezvinsky.
Aye.
Mr. Hutchinson.
No.
Mr. McClory.
No.
Mr. Smith.
No.
Mr. Sandman.
No.
Mr. Railsback.
Aye.
Mr. Wiggins.
No.
Mr. Dennis.
No.
Mr. Fish.
Aye.
Mr. Maine.
No.
Mr. Hogan.
Aye.
Mr. Butler.
Aye.
Mr. Cohen. Mr. Lott.
No.
Mr. Freilich.
Aye.
Mr. Moorhead.
No.
Mr. Mariziti.
No.
Mr. Latta.
No.
Mr. Rodino.
Aye.
Mr. Chairman.
Clerk will report.
27 members have voted aye. 11 members have voted no.
And the amendment is agreed to. The question now occurs on Article 1 of the Donahue Resolution as amended by the Sarbanes substitute as amended. All those in favor, please signify by saying aye. All those opposed, no. Call of the roll is demanded, and the clerk will call the roll. All those in favor, signify by saying aye. All those opposed, no.
Mr. Donahue.
Aye.
Mr. Brooks.
Aye.
Mr. Kastenmeier.
Aye.
Mr. Edwards.
Aye.
Mr. Hungate.
Aye.
Mr. Conyers.
Aye.
Mr. Eilberg.
Aye.
Mr. Walde.
Aye.
Mr. Flowers.
Aye.
Mr. Mann.
Aye.
Mr. Sarbanes.
Aye.
Mr. Seiberling.
Aye.
Mr. Danielson.
Aye.
Mr. Grinan.
Aye.
Mr. Rangel.
Aye.
Miss Jordan.
Aye.
Mr. Thornton.
Aye.
Mr. Dennis.
No.
Mr. Fish.
Aye.
Mr. Maine.
No.
Mr. Hogan.
Aye.
Mr. Butler.
Aye.
Mr. Cohen.
Aye.
Mr. Lott.
No.
Mr. Fraley.
Aye.
Mr. Moorhead.
No.
Mr. Mariziti.
No.
Mr. Latta.
No.
Mr. Rodino.
Aye.
Mr. Chairman.
Clerk will report.
27 members have voted aye. 11 members have voted no.
And pursuant to the resolution, Article 1, that resolution is adopted and will be reported to the House. And the committee will recess until 10:30 Monday next.
10:30 when? Monday morning.
Monday morning.
Monday night, you said?
Monday next.
Oh, Monday night.
There you have it, the first article of impeachment voted against a president, any president, in more than a century by a congressional committee. The first, in fact, since Andrew Johnson's impeachment in 1868. The vote again was 27-11, an overwhelming, a decisive margin which now assures that a resolution of impeachment against the president will be sent to the House floor. On the House floor, a majority vote, if a majority then votes to approve the resolution, then it would be sent to the Senate for trial, where a two-thirds vote would be required for conviction and removal of Mr. Nixon from office. The vote again, 27-11. The article charges the president with obstruction of justice, and basically it contends that the president lied and caused others to make false statements to Watergate investigators, that he withheld important evidence, that he approved, condoned, and acquiesced in having witnesses lie to investigators, grand juries, and to congressional committees, that he interfered with investigations conducted by the FBI, the Justice Department, the Watergate prosecutor, and congressional committees, that he approved, condoned, and acquiesced in hush payments to the Watergate break-in defendants, that he tried to misuse the Central Intelligence Agency, that he gave confidential investigative information to unauthorized persons for the purpose of misleading the prosecutors, that he made false and misleading public statements for the purpose of deceiving the American people, and that he tried to obtain the silence of the Watergate break-in defendants by leading them to believe that they would get favored treatment. Well, I suppose that in all of our lives, Jim, that we experience events and actions that affect us quite deeply. And I must say that I found this a profoundly moving experience today, the vote itself, and then, of course, the result of the vote.
The thing that struck me, Paul, I must confess, I think I'll leave the question of whether or not it is, in fact, a valid article of impeachment and whether, in fact, it will be finally adopted by the House of Representatives and lead to a trial in the Senate to others and for further water to run under all kinds of bridges. But I think the thing that struck me was just the sound of that vote a few moments ago. We had the Midwestern forthrightness of a railsback voting for, the forthrightness of a Midwesterner, Dennis, voting against. We had the high-pitched voices. We had the deep oratorical voices. We had that kind of lyrical, humorous voice of a Hungate from Missouri. We had masculine. We had feminine, Misters and Mrs. We had a New York accent of a wrangle, a similar very much for impeachment, a New Jersey accent of a Sandman, very much against impeachment. The soft Southern tones of man saying aye, the soft Southern tones of Lot, a much younger man saying nay. I was struck above and beyond the question of whether or not this turns out to be judged by contemporary historians as well as historians who should write about this 200 years from now as to whether this was a just vote or not. I must say that if you have this feeling for America and the fact that, and I don't mean to sound corny, but I know I will, but the fact is if you have this feeling for America that it is in fact, 50 states, different types of people of all ages, of all backgrounds, conservatives, liberals, etc., then you really saw it in action a few moments ago.
That's a very good view, I think. I subscribe to that because we had the Southern Democrats joining with the Northern Democrats, all 21 Democrats voting for the impeachment article today, and we had 6 of the 17 Republicans voting for it. So what happens, it seems to me, is that a strong coalition for impeachment is now emerging from the Judiciary Committee.
But above and beyond that, I mean, I'm not speaking just in terms of those that voted for, in political terms of what this may result in. I was just the fact that you're from the South doesn't necessarily mean that you're for impeachment or against impeachment. The fact that you're from New York or New Jersey doesn't necessarily mean you're for or against impeachment. The fact that you're young, Lot is a very young man, he's against impeachment. Cohen is a very young man, he is for impeachment. The fact that a man is a conservative, Hogan is one of the most conservative men on this committee, he is for impeachment. A man like Wiggins, very much of a conservative. And even the legal backgrounds, I mean, just the fact of all of these people taking the positions that they took, I was just struck by the whole thing, not so much in terms of what's going to happen from this point on.
You know what I think it proves, Jim? I think it proves what some people have contended all along, that public opinion and political pressures and what the White House did, that these actions would not really be influential ultimately, that the members would decide on the basis of their own personal convictions, on the basis of their consciences. I think that was what happened today in the ultimate showdown. I think at this point we'd like to talk to our colleague, Carolyn Lewis, who has been standing by. She's been covering the proceedings for the past 4 days. Carolyn?
To be in that room during that vote gave you a sense of unreality. It was very hard to believe that this was 1974, this was happening in the United States, it was happening under your Constitution and to your president. There was great stillness in the room. You could barely hear a pin drop as each man and each woman solemnly announced how he would vote or how she would vote. And it was a moment of really a chilling moment, because you realized that what was being done there in that very room, room 2141 of the Rayburn Building, was a piece of history and something that could change the future of this country, change the structure of the presidency, change our history. It really was an awesome moment. Turning now to the future, this particular article must go to the Rules Committee, probably within 10 days, and there'll be some discussion about the procedures for the Rules Committee to send that article to the floor. There probably will be something like 60 to 100 hours of debate on the House floor, and that could take some 10 days. Right back here at the committee, of course, next week we have several other articles of impeachment to vote on, but this particular one will shortly go to the House floor, and then the House must do its will. Back to you, Jim.
All right, Carolyn, I'm standing here at the board here. There's no point making a big thing about it. You have just seen these particular individuals casting their votes. I just think, though, for summary purposes, we should go over the ayes. The final vote was 27 to 11, 21 Democratic votes, with the possible exception of Walter Flowers, the man you have just seen who carried the many motions to amend or to strike throughout the thing. He was the only Democrat who was really in question up to the very end, and he voted. So what we really had in these 27 votes were the 21 Democrats who were there from the very beginning, plus these Republicans, Larry Hogan, William Cohen, Butler of Virginia, Fish of New York, and Railsback of Illinois. Now you go up into the nays, and then we also had Mr. Freilich. Those of you who were watching last night, Mr. Harold Freilich of Wisconsin, we had him up here as an almost sure nay vote. And through most of the debate today, as you just saw, he gave continual indications that he was going to vote against Article 1. But when it came down to the final vote, he did vote, both for the Sarbanes Amendment as it was drafted, or substitution as it was drafted, and for final passage of Article 1. So he comes down here as that 27th vote, the one that nobody expected. And then the Republicans, who've been pretty well solid all along, with the possible exception of McClory, Robert McClory of Illinois, who has said he would vote for an article of impeachment, but not for this particular article, in this case, which was Article 1, obstruction of justice. There are still many other articles to be voted on. Henry Smith went into this whole proceeding, considered an undecided vote, but he also declared himself on the first day that he did not support impeachment except possibly on the bombing of Cambodia, and that probably is not going to be a critical issue. So that, for summary and review purposes, is where it all stood at the end of the evening tonight. Paul?
Now we'd like to turn to William Van Alstyne, the constitutional scholar from Duke University, and Martin Diamond, political science professor from Northern Illinois University, who have been our guests for the committee's deliberations this week. And I would like to get the impressions of both of you as this historic climax was reached today. Mr. Diamond?
Well, kind of drained, either from the huge weight of history or endless hours of sitting in this chair, or some combination of the two. I would like to make a comment that may seem at first at a distance from the immediate event. I'm not at this moment so much concerned with the exact vote and how it will proceed instantly to the House and what might be the future of this vote when it reaches the Senate floor. But what I would like to raise is the question of why we have this impeachment power. That might be useful after watching 4 hours of nitty-gritty. The Constitution put the impeachment power in. The framers who handed us our Constitution included a clause on impeachment not to weaken a presidency, not to lessen presidential power, but precisely in order to strengthen it. And I think it's important to see that slight paradox. For the first time under the American Constitution in a democratic country, there was intended to be an enormously powerful executive. But precisely in proportion to the power given to the executive, there had to be commensurate democratic responsibility. Now, the first line of defense of democratic responsibility is, of course, popular election, the opportunity for the people to determine. They did that in 1972. They chose Richard M. Nixon by a massive majority, and his policies and what he represented was the popular will to be respected by all. The second line of defense against the possibility of abuse of presidential power or the improper use of that high office is the separation of powers. And for 4 hours today and previously, we've seen that feisty Congress with the enormous power it finally has because it has the sovereign authority of the people. The third line of defense, however, is the impeachment power. It's an emergency power. If and when an abuse occurs during a presidential term that requires that action. We have seen today an historic moment in the exercise of that power. 2 warnings. It can be a dangerous power if Congress were to take the bit in its teeth and seek to impose its policies on the presidency by means of the impeachment power. I think that's unlikely. And I think in the conduct of the committee today, we saw they mean to avoid that pole. The other danger would be to render the impeachment power useless by demanding of impeachment a standard of proof of guilt that could never in practice be achieved because high office can cover its tracks. The problem is to achieve a mean, an Aristotelian mean, a golden mean, a political mean. That mean, I think, was suggested to us by the wisdom of the Founding Fathers, especially the wisdom of James Madison, the architect of the Constitution. Grave offenses against the fundamental constitutional system.
I'd like to ask Bill a quick follow-up question to what you're suggesting, Dr. Diamond, and that is, has the Judiciary Committee now struck a golden mean with its approval of this article today?
I think it's fulfilled one of the functions of the clause, Paul, and the question was raised earlier whether this is a valid article of impeachment. I suppose we can both assume, and I think it's correct, that no court will ever pass upon that, but many people will wonder about it. As best as I can understand the clause in trying to respond to your question, I think it is a valid article of impeachment. That is not to prejudge whether or not the president can be proved guilty to the satisfaction of the Senate, but that is to say, the specification of the kinds of things with which he now stands accused are among those things, I believe, which those who drafted the Constitution had in mind in providing this means of removing the president. This is not a petition for recall. It is clearly not, as the article is framed, a mere expression of dissatisfaction of policy. The committee has set for itself a very hard task of establishing criminality in the White House. And in fact, as we've had an opportunity to think about this since the day's live proceedings, it has occurred to me now to identify the uniqueness of this proceeding. There have, in the history of the country, I think, been only 3 real impeachment proceedings. One was very early against a justice of the Supreme Court, Chase. In my view, that was an expression of fury against a political party. The Federalists had tried to entrench themselves. Chase represented that proposition, and the Jeffersonian Republicans went after him, and they failed. Had they succeeded, the impeachment clause might have been converted into a weapon of political recall, retaliation, and triumph. The second one was Andrew Johnson, and that, I think, represented the use of the clause that expressed frustration with the White House's ability to throttle Congress. That also failed, and I think rightly so, because Mr. Diamond said that essentially would use the clause to override the executive role in vetoing Congress's ambition in formulating national policy. What is special about this, and which really gives me pause, though I think it is well within the legitimacy of the clause, is that this is the first time the clause has been used to account for allegations of stark and outright criminality in the White House. I guess after I've had all of this time to think about it, what sobers me really is the accusation of criminal wrongdoing. It's not just joining the issue on policy. I think it will give the House managers, incidentally, and their counsel in the Senate a very great burden in the Senate, because it means that people are going to have to compose their judgment ultimately about motivation as to why certain things were done. And the manner in which this article is framed doesn't make it possible to oust the president because of a disagreement of policy. I can bring that full circle to your question, however, in having absolute confidence that insofar as there was original concern about the bare possibility of this sort of gross misconduct, it lies well within the authentic meaning of the clause to use it this way.
Thank you, Messrs. Van Alstyne and Diamond. We'd like to say once again that another historic milestone has now been reached in the Watergate case. The House Judiciary Committee today approving the first article of impeachment. 27-11 was the vote on the article, which charges the President with an obstruction of justice in the handling of the Watergate case. This, of course, means that a resolution of impeachment approved by the committee is now certain to go to the House floor. It is only the second time in our history, only the second time, that a congressional committee has approved articles of impeachment against the President. Jim?
And on Monday, the committee goes on to consider further articles of impeachment, and we'll be back on most of these PBS stations with our nighttime coverage at 7:30 p.m. Eastern Time. Until then, for our guests, Bill Van Alstyne and Martin Diamond, and for Paul Duke and our Impact colleagues, I'm Jim Lara. Thank you and good night.
From Washington, you have been watching videotaped gavel-to-gavel coverage of the House Judiciary Committee proceedings. Production funding provided by public television stations, the Ford Foundation, and the Corporation for Public Broadcasting. This has been a production of Impact, a division of GWETA.